Sir, Your Lordship, my second appeal, I mentioned Your Lordship.
Second appeal means?
Second appeal, sir, execution आज के लिए लगा सर. Disputed properties.
सेकंड अपील हमारे यहाँ कैसे आएगी?
सर आज के लिए सर आपका पावर है.
सेकंड अपील का रोज से जिनसे उनसे मांगे.
आज के लिए
आप 3 दिन से सुबह रोज 10:30 पे डिस्टर्ब कर रहे हैं. हमारे पास रोज है, उसके बाद भी आपकी मेंशन नहीं आ रही. हाँ? आप लोग पोर्ट स्लिप, रोस्टर में इंस्ट्रक्शंस है, पोर्ट स्लिप को नहीं देखते क्या?
Lord, may I have your lordship's kind permission?
Yes.
Lord, I am at item 28.
Today listen.
Today, it is listed at 2:30 by a judicial order. But my request is, my lord, my request is, if in turn it comes before that, if your lordships can, because going back to Ahmedabad is little more difficult from Jabalpur than Indore.
Set the number.
Yes. No, my request was, since it's at 2:30, but if it reaches earlier, my request is subject to your lordship's convenience. Your lordships may kindly take up. Please, my lords.
Lord, I have filed an application for amendment to provide correct address of respondents number 9 and 10 for the issuance of notices. And notice to respondent number 8 is also awaited, my lord. I pray for, my lord, time to pay PF, fresh PF, my lord, regarding correct address of respondent number 8, my lord.
So they were not served with the writ petition?
They were served when the writ petition, my lord, they appeared. But in the writ appeal, my lord, fresh notices were issued. And, my lord, though some address, there was some incorrect address.
What is the matter?
My lord, the matter is regarding, my lord, dismissal of the writ petition as withdrawn, my lord.
As withdrawn?
Yes, under collusion by the petitioner and the respondents. Though, my lord, the agreements have been executed by us.
That it was not, never withdrawn.
My lord, after that, my lord, we preferred another writ petition on the basis of the agreements executed with us, my lord. And in that writ petition, my lord, the order has been passed, that is annexure A2, my lord. And I have been directed, my lord, to prefer the writ appeal, my lord. Liberty was granted on that basis, my lord, because I preferred application for intervention.
And even second writ petition was not maintainable, so that liberty has no meaning.
My lord.
But if you have filed a review petition saying that that withdrawal was
My lord.
there was an application for withdrawal.
Application for withdrawal by the petitioner, my lord. Though the agreements has been executed with me, my lord.
You are including your own IA.
No, I am not. That IA was not filed by me, my lord. I preferred application for intervention on the basis, my lord, that agreements have been executed with me and I am a necessary party because the petitioners already executed. And
This is not appeal filed by the writ petitioner.
No, my lord.
No.
He's the intervener, my lord.
my lord, this is the writ appeal filed by the though there are.
If the petitioner was not inclined to pursue his writ petition, then you can't object to it.
My lord, I can object to this, my lord, because, my lord, this writ petition has been dismissed, my lord, simply on the basis, my lord, that the power of attorney executed in my favor expired, my lord, after the death of the executor of the power of attorney. But, my lord, there was an agreement which has not been taken into consideration that was already placed on record that the legal heirs of the executor of power of attorney already executed agreements with me for sale, my lord. And these were.
Counsel for intervener, Mr. Srivastava, opposed. Seriously,
he opposed, but this document has not been considered.
This order was not passed behind your back.
No, it has been, it is a bi-party order, my lord. But I did not dispute, my lord. But my lord, this fact has not been considered that the agreement has been executed with me. My lord, may I please to consider the impugn order, my lord. In the last para, my lord. Yes, my lord. Yes, my lord. Yes, Dr. Anwar Srivastava.
For the application for withdrawal, the petition.
Yes.
The application.
5659.
कहाँ पर है विंडो हाई 54 विंडो the petitioner was telling the order to be filed by the LCA public application that part during
Without stating any reason, my lord, this application was preferred by the petitioners. Though, my lord, after the death of the petitioner, the LRs were brought on record and those LRs already executed agreements with me, my lord. And those agreements were there on record, my lord. Prior to that, my lord, the power of attorney was executed with me. That power of attorney was also placed on record and the learned single bench, my lord, considered only that the power of attorney has lost its efficacy after the death of the executor. Now, my lord, the agreements have not been taken into consideration that the legal heirs.
the value of it? The registered agreement?
It's a registered agreements are there, but agreements, my lord.
Establish your right
And-
on the basis of.
My lord, on,
For a specific purpose.
my lord, the fact is,
Get
my
your
lord,
right established.
my lord, the fact is, my lord, that this petition has been preferred against the registration of a public trust, my lord. And the basic question is, my lord, that the power, my lord, exercised by the SDO is not vested in it, my lord. Because there is a series of judgments passed by this honorable court that only collector is the registrar and it can exercise the power for the registration of public trust, my lord. Though without any authority, the SDO has passed the order that we have questioned, my lord. And secondly, my lord, the application for the registration of public trust has been preferred by one Amina Pereira who, on the basis of power of attorney, and the executor of that power of attorney died before that consideration of that application. So that application itself was not maintainable. These were the two legal issues, my lord, were required to be decided. And my lord, on that basis, my lord, we preferred this application for intervention that they are in collusion and they want to withdraw this petition, my lord, just to deceive me, my lord, because agreements have been executed with me. And my lord, my application has not been considered properly, my lord. And the entire petition has been dismissed, my lord.
Girdhari Lal Kushwaha is the attorney holder.
Attorney holder, and thereafter agreements were also executed in his favor by the legal heirs of the executor power of attorney, my lord. Annexure IA5 with my application for intervention, my lord.
वही देगा
My lord. I have filed the agreement, my lord, which has been executed by the legal heirs of the deceased power of attorney executor, my lord.
How the legal heirs of power of attorney holder can pursue the litigation?
My lord, they were already brought on record. They were impleted as petitioners.
Please explain the law.
My lord.
Power of attorney comes to an end immediately after death of executor as well as
Yes,
attorney holder.
yes.
How the legal heirs can continue?
No, not legal heirs of the power of attorney holder, my lord.
Ah.
The petitioner died, my lord, and his legal heirs were brought on record, my lord.
Petitioner was the attorney holder.
Petitioner earlier was the attorney holder of the deceased petitioner, my lord. But thereafter, my lord, the legal heirs of the petitioner also executed agreement in his favor, my lord, that the agreements which have been executed by the deceased petitioner will be binding on them as well, my lord.
And even in trust matter, civil suit lies, sir, not writ petition. To challenge the order of the
My lord,
order of SDO.
My lord, submission is, my lord, that if the order is passed illegally, my lord, without any jurisdiction vested in it,
Litigation.
my lord, if the order is passed without any jurisdiction, my lord, then the writ petition is maintainable, my lord.
Section 8
What is your
remedy.
right, to intervene in the writ petition which has been withdrawn? Locus to intervene, yes, writ court has rightly held that, you have no locus to.
My lord, only power of attorney has been considered, but
Writ appeal is filed against the order dated 10th February 2025, whereby the writ petition 1050/2014 was withdrawn by the petitioner therein by filing an application for withdrawal. The present appellant, being an intervener, seriously objected to the withdrawal of the writ petition. The writ court considered the objection and found that and rejected, not only rejected the application for intervention, but also the objection of withdrawal on the ground that he has no locus on the strength of several power of attorney given by deceased Rajesh. Therefore, the petitioner who was only an intervener who filed an application, appellant, sorry, the appellant who only applied for intervention in the writ petition has no locus to object to withdrawal of the writ petition and challenge the withdrawal by way of writ. Not only this, this present appellant filed a fresh writ petition and withdrawn with liberty to file this writ.
my lord,
Not find any error.
my lord, the liberty may kindly be reserved.
Petitioner, appellant has no locus. Even otherwise, after the death of the attorney holder or the executor of the attorney holder, the attorney or attorney comes to an end. So far, the claim based on the agreement to sale, the petitioner has a remedy elsewhere or to intervene in the writ.
My lord, I may prefer review petition if my lord may please to
For you
reserve.
to advise your client, Mr. We are not here to advise.
I'll agree to that.
Obliged.
But I'm appearing for the respondent number 4 in this petition. But the petition has rendered infructuous. The civil suit has already been decided. Now the appeals are pending.
Let the appellant say so.
My lord, in this matter, my lord, the parties are already before mediation, my lord, before the Delhi Mediation Center, my lord. My prayer is this may kindly be listed with first appeal 401 of 2005, in which the mediation is already initiated, my lord, by this honorable court.
This petition is filed against which order?
My lord, the final order which is given by the commercial court, my lord, the MP in this, some of the other orders have been challenged, my lord. The mediator has only asked to refer all the cases in mediation.
The respondent submits that he has rendered infructuous.
No, my lord, it has not rendered infructuous because the orders which are challenged in this miscellaneous petition, my lord, while the case was going on, is not been addressed till yet in the final order. And as well, my lord, the cases are all referred in mediation. All the matters between the parties are referred in the mediation, so there can be an amicably understanding between the parties, my lord. All the matters between the parties are referred in the mediation, my lord. And the appeal
is pending before division bench or single bench?
yes, my lord, it is pending before the division bench only. This high court only, my lord.
My lord, they may raise all the grounds which are there in the petition, my lord. This petition cannot be adjudicated, which is an interlocutory order they have called in question here.
Now, my lord, this is
All the grounds are available to be raised.
they are raising these points here while the mediation is going on. Then again, when we'll start the same procedure, they'll say that we are not cooperating.
It's not like this. I'm just mentioning that this petition is not worth to be adjudicated now. Now the appeal is pending. You may raise all the grounds in the appeal. I'm not saying that we are not in mediation.
What is the number of the
First appeal 401/2025.
It is 26, not 25.
Sorry, my lord. I am extremely sorry. 26. It is listed for 17th of July, my lord.
Not 17th. It is listed for 15th of July.
Court's first appeals are pending before this court. While order dated 15/5/26, this court has released the parties to completion. Hearing of this case is deferred and list report. List along with first appeal 406 of 2000.
401, my lord. My lord. Obliged.
I am not obliged, Lord.
Well, these are the matters, 6 and 7. Both are the matters where the Honorable Court has taken the cognizance in respect of the conditions of schools in the state of MP. We have filed a detailed status report, as well as we have mentioned that there is a UDI system, which is a very unique system where all the schools headmasters are having the facility to inform about the deficiency in the schools. So day to day in the month, they put their problems before the and we are rectifying and implementing the same. So in respect of those two schools, which starts from the newspaper, they have been, the conditions have been improved, and now the dilapidated school have been demolished and the new constructions have been started. So we have filed the photographs and relevant documents in this.
Why you woke up only when the High Court?
No, these things are going on.
There are still,
Yes, man. Yes, this is a process, which yes, very true, but for that, this system we have introduced by the central government, which is we have mentioned at para number 14 of my reply, the compliance report, where we say that this system is very effective, because every headmaster of the school is directly connected with the higher authority, and they can put forth whatever the problem in the school, put in that system, and that would be rectified by. And my lord,
The point of committee to
as my lord deems, my lord, to,
report and examine your report and.
yes, yes, sir, very, my lord, no, no, my lord, very, that will, my lord, grateful, my lord. Yes, great, great. In item number 6 and 7, I have just relied upon the report which I have filed in this both. It's a single, same, my lord. So we have adopted that report which we have filed in this petition.
Why is this second is what, 7 number?
My lord, two different newspaper newses are there. My kindly see, my lord.
Both the PIL are related to the similar issues regarding the condition of the
School,
government schools.
government schools, government schools.
State of Madhya Pradesh. Therefore, both the PIL are merged and only one WP 16077 of 25 feet. District report is 4 and 16079 25 is treated as merged and disposed of. एक ही चला है.
Please. There is one more petition was pending, my lord. For that also we have answered it, my lord. That is, my lord, I'm just letting my lord's number know.
And the
That-
we have perused the report. We will find it appropriate to appoint a committee for assistance of this court.
Thanks.
Grateful.
Like, like.
Hardship in this case, we are filing the affidavit today. An affidavit was called by the honorable court. That affidavit we will be filing today.
Number 8.
Number 8.
Going to file. Against which order this contempt appeal is filed? This order is classified here.
Lordship, this is against the order C1, Lordship.
C2. C1 is the order of the petition.
C2 होगा भाई.
C2 is the order.
So dismiss we have contempt.
Lordship, they say that the compliance has been made, but the order original.
Contempt appeal is maintained. Again, the dismissal of contempt.
Lordship, in the contempt petition, they did not comply the order which was passed by the original court, Lordship. C1 may kindly be seen.
Read that section for contempt appeal lies only against the order of
Conviction. That is their Lordship, but then again, the petitioner is
compliance order if it is according to you, this in writ court you can challenge.
Lordship, the petitioner is already contesting this case since 2014. There was clear-cut direction. C1 may kindly be seen, Lordship.
But the scope of contempt appeal is limited.
Lordship,
Then file SLP against that order, but not a contempt appeal.
there was a clear-cut direction. I respectfully submit, Lordship.
By which? Even. It's not a case of willful disobedience.
Lordship.
There could be a misunderstanding or misrepresentation or, but not a willful. They have decided your claim and rejected. You may challenge this order dated 15/1/26.
Lordship, they say that I cannot be promoted, but there is an order on merit which says that I must be promoted. At page 18 of the C1, Lordship. The circulars which they are relying.
Line as of a right from any order or decision of a high court necessary to be punished for time. Then there will be. क्या आपको रीड कमेटी की रिपोर्ट है?
Lordship, this was for considering my case for promotion in light of
क्या
the
वर्ड हो जाता ना, लेकिन ना एक फाउंड लगाए ना, this petition is found suitable.
Lordship.
According to both the petition, succeed and hereby allowed the order to be given to an that on availability of the post, the case of routine shall be considered for submission to the post or something user extend UP. The petitioner are found suitable, their case will be recommended for promotion. ये तो consideration था.
Lordship, they did not consider my case in light of 138/2012. Anywhere in the compliance. Anywhere in the compliance, they did not consider my case in light of 138/2012. And it cannot be a case that the posts were not available.
तो आपको officiating charge दे दिया गया.
That was rejected by, that petitioner rejected to accept the officiating charge.
तो अभी सभी को वही दे रहे हैं आप, रेगुलर प्रमोशन तो हो नहीं रहा किसी. Everybody is getting officiating charge now. Until unless that promotion matter pending before it is decided. No one is getting regular promotion. Why you have refused the officiating charge?
Should that has to be under SOP 138. They are taking some subsequent SOPs. Earlier, I had already got the order squashed and there is an order on merit to consider my case in light of 138. I fail to understand what bars them in considering my case under 138. That order still stands. They did not appeal it, review it. I continued to fight since 2018 in the contempt petition, and then they come up with a case that 138 cannot be applied to you. In the merit, they do not say so. And the court has relied upon the applicability of SOP 138 upon me.
Lakhs of employees have been retired without promotion. किसी को पदोन्नति नहीं दी गई. You know the condition in the state of MP. No one is getting a promotion. And merely because you have completed 5 years of service as a constable, that doesn't give you the right to claim for promotion. It is always subject to availability of the post and
It is not the case, Lordship, that the posts were not available.
Your entire case is based on the ground that I have completed 55 years of service. Therefore, I have become eligible for constable and I should be promoted.
Lordship, and this was examined by the writ court. This was examined by the writ court and writ court already said if I am eligible, I must be promoted under SOP 138. They say that that is not applicable to me.
It gives you right only for consideration, not to claim as a matter of right.
It cannot be a case, Lordship, that is still the posts were not available. After lapsing a
Court of the writ petition by giving direction to the respondent to consider the claim of the petitioner for promotion on the post of head constable. And if they are found suitable, their case may be recommended for promotion in accordance with the respondent. Thereafter, the petitioner filed a contempt petition, the respondent filed a compliance report. The contempt court recorded its satisfaction that it is in compliance, not in willful disobedience. Even otherwise, under section 19, the appeal lies against the order passed by the contempt single bench dealing with the contempt matter. Where the order or decision has been taken to punish for contempt. Therefore, again, the dismissal of contempt petition regarding the satisfaction about compliance and no appeal will die.
Obliged, Lordship.
The matter pertains to the mutation mallet. The writ petition and the review petition was dismissed mallet without, the writ petition mallet was in fact dismissed without any opportunity of hearing to me mallet. Let me see the last para in the writ petition mallet. Under these circumstances where applicant has prima facie failed to establish a relationship with the Girjabai, coupled with the fact that this court has not deprived either applicant or respondent number 5 in perpetuity, but has merely set aside the order of mutation with liberty to either of the parties to approach the civil court for execution of the right. The court is of considered opinion that no prejudice has been caused to the applicant on the account of the order. Sorry, Madam, I'm reading the review petition order. Sorry. Last para in the writ petition.
So there are you filed a review petition.
Yes, my lord.
That has been dismissed.
That was also dismissed, my lord. Now the case is, my lord, based on the will, and the commissioner, my lord, that allowed my case, my lord. Thereafter, this writ petition was filed. In the writ petition, my lord, the direction was given to approach the civil court, and the land was also directed to be given to the state government, my lord. And there was a liberty, my lord. Since this order is being passed on day 1 without issuing notice to respondent number 1, therefore it is directed that in case respondent number 1 feels
So your review was entertained,
my review was entertained.
but on merit it has been dismissed.
My lord, the same order has been passed, and the land was the parties were directed to approach the civil court, and the land was directed to be handed over to the state government. My lord. So the genuinity of the will, my lord, that has been disputed, my lord, by the landed single. Although my lord, both the parties have not disputed the bill.
Then where is the dispute?
There is no dispute, my lord.
Then why you all are in court?
In fact, he filed the writ petition. Thereafter, he prepared the writ appeal. That writ appeal, my lord, thereafter was he did not appear, my lord, and that was also dismissed. But there is no dispute in respect to the civil.
None of the parties are the first legal heir for Girjabai.
Yes, my lord. But there is a panchnama, my lord. There is a panchnama in the favor the favor, my lord.
You will have to get a decree, a declaratory decree from the civil court that who will succeed the land of Girjabai. Otherwise, it will go back to the government.
My lord, but there is no dispute, my lord. Neither the respondent is challenging the will, my lord, neither I am challenging the will. So there is no dispute, my
Both are before the court.
my lord, in fact, that he filed, my lord, because he wanted the will में, my lord, दोनों को ही दिया हुआ है. But because
Civil suit is remedy.
partition suit cannot be filed, my lord, because there is a will. And when judgment, my lord, I have uploaded in the Supreme Court. Tarachand judgment, my lord.
Once for all, these issues should be decided by the civil court. Both the parties have contested the matter before the revenue court up to the commissioner and then file a writ petition. So there is a serious dispute between you and the respondents.
Yes.
It is better to go to civil court and get
My lord, what my prayer is, my lord, at least in the writ petition, my lord, an opportunity of hearing may be given to me, or the notices may be sent here to the.
gave you the hearing in the review.
My lord, but there also, my lord, the respondents were not given any notice, my lord. So.
एक बार उनको सुन लिया, एक बार सबको सुन लिया.
And my lord, I have also uploaded a judgment, my lord, in.
Which judgment?
Mano, that is Tarachand versus Bhawarlal, Mano.
क्या कह रहे हैं?
Mano's mutation based on will held there is no prescription in the 1959 code against the acquisition of rights and land through a will. Revenue authorities cannot reject a mutation application at the threshold simply because it is based on a will, whereas SLR cannot adjudicate complex disputes regarding the authenticity of will, validity of a will, which must be decided by the mutation should not be denied where no serious dispute is raised by the natural legal age of the deceased. And this is also the Panchnama, Manoj, which I'll file this also, Manoj. File this with affidavit, Manoj, because recently I've received this.
What is the value?
This was based. The original oral malus, she was issueless, and she took these appellants malus under her.
इसमें भी finally Supreme Court has observed that the mutation entry, however, shall be subject to any adjudication by competent civil court or revenue court. So,
If there is a dispute, my lord, but there is no dispute, my lord, in respect to.
all the parties jointly file an application and get your name mutated according to
My
the
lord.
partition.
My lord, then notice may be served to the issue.
नहीं अगर आपको कोई dispute नहीं तो you can do it out of court. Why we are required to call them here? Dispute नहीं तो why you are?
Because right now, my lord, they are having the entire land for their own. The respondent number 5. And he has built a petrol pump over there, my lord, and even the direction that the government my lord, that the land may be handed over to the government, my lord, that is also not there.
में है observation.
My lord, in the writ petition?
नहीं ये judgment जो आप कारक हैं.
My lord. Lord, by the order of the Resident Commission, because of quantified missing is to the High Court under 27, that the High Court by the short order of placing the land on the salary receivers and which 20 set aside the order of the revenue authorities and directed the names of legal heirs of so-and-so as per 1952 tax shall be mitigated. If they are not available, then the land shall be recorded in the name of the state government. The High Court, however, clarified that the road direction shall be subject to the outcome of the civil suit pending between the parties. So, that is pending, Manoj. That in that manner the bill is disputed. But if the bill is not disputed, then
when you are fighting against each other, the bill is disputed. Otherwise, there was no occasion to challenge the order of mutation before the SDO, then before the commissioner, and before the High Court.
What my press said, the reply.
The facts I would like to point it out. What happened in this case, the name of the only my brother was recorded in the revenue record. So I submitted the will, then my name should be recorded. On the basis of that, my name was also recorded. He challenged that order before the commissioner. And that petition was dismissed. In fact, commissioner order was in my favor. He filed the writ petition. Without any notice to me, order of commissioner has been set aside, sir. So first, my respectfully submission is that the how. But at second stage, the report heard you and passed a detailed order. No, not heard me, but what in the review petition also in a admission stage it has been closed for order and dismissed. It is not the case that they were called and I was permitted to file. But Mr. Yadav, there is a dispute between you in respect of them. No, there is no dispute. They are not. What my respectfully submission, only one person, they are not accepting the will in your favor. It is not the case, but he also not disputed the will, but in the revenue record, only his name is recorded. This is the problem. That's why I filed the appeal that my name should also be recorded, because in the will, my name is also mentioned.
Both will become the joint order.
Yes. So what my respectfully submission is that respondent's alone name has been mentioned.
Well, at first instance, when you filed an application for mutation, why you did not request for Tahsildar to record his name also on the basis of?
Yes, yes, this is what my submission is. That both names should be recorded. So that was allowed. That was allowed by the Revenue Authority. That was allowed by the Revenue Authority. And because what had happened when the commissioner has passed order in my favor, that
Complete share.
no, he alone is enjoying entire property. That's why I moved the application, because in the will, my name is also mentioned. And ultimately, what had happened when the commissioner has passed the order that the name should be recorded as per the will. He challenged that order before the Honorable Single Judge. That order has been set aside. Still, he's holding the field, sir. Still, the respondent number. In fact, today it is listed for the consideration of delay, sir. There is a delay also.
That we can consider. But the problem is, Mr. Yadav, if there is dispute between you and your brother, and according to you, there is a partition in the will between you. The civil court will do that.
नहीं sir.
Civil court will declare that your share and.
नहीं sir, मेरा वो निवेदन नहीं है सर. इसमें dispute सिर्फ इतना है कि रेवेन्यू रिकॉर्ड में सिर्फ चंद्रेश का नाम रिकॉर्डेड है. My name is not there. So I moved the application. Then my name should also be recorded because I was also given the share. But that was not done.
By the.
Well, in fact, that was yes. But not. But he has not denied the will. He has not denied the will. In nowhere he said that because on the basis of will he is also getting the benefits. The partition is different thing, sir. It is revenue authority is only for the physical entity, not in respect to the titles. What my respectfully submissions were.
Will relegate to the civil court both the parties. Let him come.
But
Also, what has happened in this case, Lordship, the petitioner purchased the suit. The petitioner purchased the suit property in the year 2024 from the erstwhile owners who are respondent number 528. Now, their father, the name of the father of were recorded. He was granted Bhumi Swami rights in the year 2003 by the state government. Prior to that, his father was government lessee. Now, what has happened? Some anonymous complaint was made recently. The collector exercised suo motu power under section 165(7)(b) that the land cannot be transferred in the government land in which the Bhumi Swami right has been given by the government under 165(7)(b). That land cannot be transferred without the permission of the collector. The collector exercised the power, and instead of cancelling the sale transaction, or collector ought to have directed to file an application to take necessary permission. He passed an order for disposition and also for forfeiture of the land. Now, this order has been passed without issuing any notice or without affording any opportunity to the erstwhile owners, because the land they were given the Bhumi Swami rights in the year 2003, and the government has forfeited the land in the year 2025. Now, this has been, if the order may kindly be turned on, Lordship, the impugn order of the that is in writ petition annexure P1 passed by the collector. Lordship may kindly turn on to page 19. Now, this is 165(7)(b) powers have been has been
P1.
page 19.
Who was the complaint?
complaining for is respondent number 4. He has no right or title over the land. He is a press reporter. He is some anonym. He is a third party. Like the collector can direct to file necessary application, or at the worst can direct to cancel the sale transaction, but cannot forfeit the land which was granted to 2003, and that too without affording any opportunity. The power has been exercised under section 182 for disposition. Lordship may kindly see the impugned order first, Lordship. Page 19. प्रकरण का अवलोकन किया. Second paragraph. प्रकरण में प्रस्तुत दस्तावेजों तहसीलदार धूलकोट अनुविभागीय अधिकारी के प्रतिवेदन से स्पष्ट है कि सोमा से उसे ग्राम आसेर की कृषि भूमि स्वयं का वर्ष 98-99 पट्टा जारी किया था. यह भी स्पष्ट है कि उपरोक्त भूमि में से इंदौर 4 लेन मार्ग का निर्माण होने से क्षेत्रफल स्वयं का अधिग्रहण किया गया है. तहसीलदार नेपानगर के राजस्व प्रकरण दिनांक 29/9/2003 द्वारा सोमा को भूमि स्वामी अधिकार प्रदत्त किए जा चुके. सोमा के अलावा से मैंने खरीदी है तथा उक्त सोमा की मृत्यु के बाद उसके वारिसों सुभाबाई एवं 3 द्वारा सुधीर को प्रश्नाधीन भूमि विक्रय पत्र 11/11/24 द्वारा विक्रय की गई है. नाउ द प्रोविजंस ऑफ 165(7) आर कोटेड. नाउ अथवा जिसे कोई भूमि सरकारी पट्टेदार के रूप में दखल में रखने का अधिकार राज्य सरकार या कलेक्टर द्वारा दिया जाता है, और जो तत्पश्चात ऐसी भूमि का भूमि स्वामी बन जाता है, ऐसी भूमि का अंतरण कलेक्टर की पद श्रेणी से अनिम्न पद श्रेणी के किसी राजस्व अधिकारी की अनुज्ञा जो लेखबद्ध किए जाने वाले कारणों से दी जाए, ये बिना नहीं करेगा. उपरोक्त प्रावधान इस प्रकरण में लागू होते हैं. इस प्रकरण में विक्रेता सुभाबाई वगैरह द्वारा उपरोक्त प्रावधान अंतर्गत अनुज्ञा प्राप्त किए बिना ग्राम आसेर की कृषि भूमि स्वयं का विक्रय किया गया है. Order of disposition is passed.
Also, hold on a question of interest with the next rate of gain. So, the status for the check of position, alienation. You will not say.
I will not alienate.
My lord, in this case, the dispute is that, my lord, whether the respondent who were petitioner in the writ petition, my lord, they were satisfying the twin test for the captive generating plant and whether they are entitled for the rebate or not, my lord. Now, my lord, before the writ court, we have seriously disputed their status as a captive power plant on the ground that they have not undergone the verification process for that particular purpose, my lord. Now, my lord, for a generating plant to be a captive plant, my lord, the requirement is provided under section 9 as well as rule 3 of the electricity rule 2005, my lord. Now, my lord, there are two requirements. The first requirement is that, my lord, the ownership of 26%. And the second is, my lord, 51% of the generation from that plant is required to be consumed by the captive user, my lord. Now, my lord, there is a verification mechanism, my lord. Up to 2023, my lord, there was no formal mechanism. So what the procedure the companies were, or the generators were adopting, they were filing a petition before the MPERC, and MPERC was directing various authorities, my lord, that who will verify that particular status and confer the benefit of captive generating plant, my lord. Now, 2023, for the first time, the MPERC has framed a rule, a regulation, my lord, for this particular verification. And now the designated authority is SLDC, my lord, the chief engineer of SLDC, who will do it, my lord. Now, in 2024, there was a dispute that who will verify this particular status, my lord. So in petition number 72/2022-23, my lord, the MPRC has said that prior to financial year 23-24, this verification will be done by the respective DISCOM, and after my lord 2024, my lord, the chief engineer of SLDC will do. Now, my lord, the impugned order which has been passed.
Status of captive.
My lord, the impugned order has been passed.
So you change every year.
My lord, every year.
Subject to.
My lord, subject to consumption, my lord. Subject to consumption and ownership, my lord. It is required to be verified every financial year, my lord. If they have not, let's say, my lord, the consumption of a particular power plant generation consumption is less than 51%, my lord. In that case,
if electricity is consumed by the owner or it is sold, how you are affected?
My lord, there is a rebate, my lord, which is being offered. What happened, my lord? We are power surplus. We are rebate, my lord. What happened that now we are power surplus state, my lord. So, my lord, a scheme has been launched that if
you had a scarcity, you promoted the
captive generation. My lord.
They invested money and established their captive power plant. Now you are saying now, because of their captive power plant, you came into this.
My lord, now, since my lord, they are.
How can you go by that percentage?
No, my lord, my lord, we.
On your request, they established their.
My lord, it is the dispute.
Several other.
My lord, the dispute is different, my lord. We have made an offer. My lord, we have made an offer, my lord, to the captive generators that if they start consuming from the grid, my lord, from the DISCOM, we will give a rebate of 2 rupees per unit on this particular, on their reduced capacity. Let's say they were generating 50 megawatt, my lord, and they reduce the capacity to 30 megawatt. So, my lord, on 20 megawatt of this reduced capacity per unit price, my lord, we are offering 2 rupees rebate, my lord, for their increase in consumption if they start consuming that electricity from us, my lord. So that here the dispute is this, my lord, that the petitioner claimed, my lord, that they were captive generators, my lord. And from 2019, they have reduced their capacity, my lord, reduced the capacity and increased the grid consumption. So they are entitled for this 2 rupees debate, my lord. 2 rupees rebate under the tariff order, my lord, relevant tariff order. Now, my lord, in this petition, my lord, when they have filed the petition, we have disputed their captive status. They are not qualifying this particular twin test and they have not undergone the verification process so that they can avail this report. But we do not have any issue, my lord, if they keep generating and consuming themselves, my lord, that is not the matter of our concern, my lord. But if they are claiming rebate, if they are increasing the intake from the grid, my lord, and they are claiming rebate, then for that purpose, my lord, this particular verification has to be done. Now, there was no verification for this purpose, my lord, but surprisingly, my lord, the writ court has arrived at a conclusion that they are captive generated. My lords can have a few paragraphs of the writ petition, my lord, which will make the issue clear that how the issue has been dealt by the writ court. Now, whether they are having captive status or not, my lord, para 12 of the, where our submission has been recorded, para 12, my lords can come to page, second page, page number 9.
You are referring
impute order, my lord. Impute order. A1. Pardon, my lord? Para 12. Para 12.
Well,
it is at page number 47, my lord, running page number of 9 of the impute order.
on notice.
On notice. No, my lord, I am skipping the initial pages, few lines. My lords can straight away come to para 47. The last 7-8 lines, my lord, after 26 to 2020, my lord, it is towards the middle of the paragraph.
Read the complete paragraph.
My lord. On notice being issued, a detailed reply has been filed by the respondent number 2 to 4 denying all the petition ever. But it is contented that by order dated 3/5/2018, the MP Electricity Regulation Commission has issued this specific terms and condition providing rebate to rupees 2 per unit for captive power plant consumer under clause F5 of the tariff or schedule HV3. On incremental units of the consumer subject to reduction in the captive generation as per methodology mentioned therein. The rebate under clause F is limited to captive power plant consumer only as per section 12 of the Electricity Act. The petitioner applied for the benefit of rebate. As application was duly processed and by letter dated 29/6/2019, he was informed about the direction of Chief Engineer so-and-so Jabalpur that the petitioner shall be eligible for rebate as a captive plant as so-and-so on fulfillment of the terms and conditions. On this letter, no decision was taken by authority holding that the petitioner is entitled for the rebate as per captive power plant consumer. The proposal for providing captive rebate, unit rebate to the petitioner was thoroughly examined by respondent number 4 and by letter dated 26/2/2020. He was informed that the terms of circular, the petitioner did not fulfill the eligibility criteria for captive rebate and was not eligible for captive unit rebate for the reason that the petitioner was given ST connection of 2500 kVA contract demand at 132 kV supply voltage on 24/12/2008. According to the condition mentioned in circular dated so-and-so, issued by Chief Engineer MP so-and-so, the consumer having 132 supply has to take permission for setting up generation for captive power plant from managing director so-and-so was not taken by the petitioner, and no agreement was executed by the petitioner for setting up captive power plant. It was further contended so-and-so by letter dated so-and-so informed that respondent number 3 regarding the procedure for availing rebate for captive power plant consumer under clause F5 of so-and-so, in pursuance to which the respondent number 4 by dated informed the petitioner to submit the information as prescribed format. I am skipping few para, my lord, because this particular captive status, my lord, that was disputed. Further specific contention is at para 17, my lord. We said specifically that they are not satisfying. There is no process of verification of satisfaction of twin test, my lord, para 17. It is argued that the petitioner has been filed challenging the impugned show cause notice, which is not maintainable in view of the judgment passed by so and so. He has further relied upon the qualifying criteria of CPP, that is requirement for captive generating plants, as mentioned in the section 9, read with clause 8 of section 2 of the Act. The petitioner is not fulfilling the eligibility criteria, therefore not held entitled for rebate under CPP. So, my lord, this was specifically disputed by us, that they do not fulfill the criteria of CPP. Now, para 21, when the court has started the adjudication, the court has started with the letter report has started with the presumption that they are having captive status at the only dispute.
Where is this circular dated 12/4/20? 12?
12/4.
12.
12.
3190. You are relying on this circular?
My lord, I am relying upon the rules, my lord. I am relying upon the rules, which requires, my lord, this particular consideration, my lord.
Where are those?
The rules are 2005 rules, my lord. Reference, my lord, the first reference, my lord. Electricity rule 2005. This is serial number 1, my lord, in the document uploaded by. My lords can have rule 3.
3.
No power plant shall qualify as a captive generating plant under section 9, read with clause 8 of section 2 of the Act, unless in case of the power plant, not less than 26% of the ownership is held by captive user, and not less than 51% of the aggregate electricity generated in such plant, determined on annual basis, is consumed for the captive users. So every year it has to be determined, my lords. My lords can have further, this clause is required to be complied. My lords can come to second page, which is dealing with section 322, my lord. It shall be obligation of the captive user to ensure that the consumption by the captive user at a percentage mentioned in subclause A and B of subrule 1 above is maintained, and in case the minimum percentage of captive use is not complied with in any year, the entire electricity generated shall be treated as if it is supplied to electricity by a generating company. So the ownership equity share is also required to be maintained every year, and the ownership criteria, the consumption criteria is also required to be maintained every year. Now the process of verification is prescribed by A3, my lord. Next, A3 may be seen. MPERC has prescribed a detailed procedure for verification of this particular exercise, doing this exercise, my lord. Because the rules are silent that which is the authority which will undertake this particular exercise. So the procedure is prescribed under A3, my lord. This is the regulation which is ruled as Madhya Pradesh Electricity Regulatory Commission verification of captive generating plant captive user regulation 2023, my lord. Now a detailed mechanism has been prescribed by the MPERC that how this captive status of a particular entity is to be verified, though this particular rules have been made applicable from the financial year 23-24 onward, my lord. And the designated authority is A2, that designation notification is A2, which designate Chief Engineer SLDC MPPCL as a designated authority for carrying out that particular exercise. My lords can have A2 para number 5, where it is an order passed by the MPERC, which is prescribing the authority for conducting for purpose of verification of the captive status. Para 5 of A2, my lord, page number 76. Now a question arose before MPERC that since this regulation has been moved in the year applicable from the financial year 23-24. So what should be done? The issue prior to that, my lord. Now that issue has been dealt in petition number 72/2023, which is also uploaded, my lord, which is at serial number 4 of the reference, my lord. And for the first time, my lord, by this order, the MPERC has clarified, my lord, that is 22nd March 2024, that after these regulation, for the cases which are up to financial year 23-24, that should be done by DISCOM. And for those cases which are after financial year 23-24, my lord, that will be by Chief Engineer SLDC, my lord. Prior to that, the procedure was that, my lord, that any person who is wanting this particular verification process, my lord, he will file a petition under section 86 of the Electricity Act before MPERC, and from case to case basis, MPERC was directing the authorities to undertake this particular process. Now here the petitioner, my lord, who are the respondent here, my lord, the writ petitioner, have never undergone this particular process of verification of their captive status. And this particular issue has been specifically raised in the writ petition. Now to our surprise, in para 21, the writ court has arrived at a conclusion that the only issue which is the sole question which is consideration is that whether this rebate can be extended to them or not. Para 21 of the impugned order, which is at page number 50, the writ court observed the sole question which crops up for consideration before this court is whether Camor Cement Unit Katni captive power plant is operated by petitioner is entitled for the benefit of rebate in terms of scheme, that is captive rebate scheme. So despite there being a very disputed question involved with respect to the very captive status of this particular plant, the court proceeded with the premise that they are having a captive status and whether they are entitled for rebate or not, my lord, because the ancillary issue to that particular case has been dealt with. Now, para 33, again, we have raised an argument when the court was making analysis of this particular provision. It has been specifically argued in para 33 by us. It is argued before this court that for determining the captive status, which is governed exclusively by Rule 3 of the Electricity Rule 2005, which prescribed the twin criteria, that is minimum 26% ownership, and second, consumption of at least 51% of generation on the annual basis, the impugned communication are entirely silent.
This condition they are not fulfilling.
My lord, my submission is that, my lord, there is no verification process of fulfillment of this particular condition, my lord, because
there is no verification.
No verification.
Then on what basis you are denying the status of?
My lord, unless and until they are verified as a captive user, my lord.
Either you should verify or there must be some independent authority.
My lord, my submission is that is precisely what I am making submission, my lord. They have to approach in year 2019, my lord. They were required, my lord, up to 2023, MPERC was deciding this particular issue. They have not approached MPERC. From 2020,
then you should approach.
My lord, the difficulty is that, my lord, if you want to have that particular benefit, my lord, from us, the first thing is that you should have a certification of your capacity.
But that authority has not been defined in the rule.
It has been, so that is the reason, my lord, if there is any ambiguity in the act or rules, my lord, MPERC is the authority, my lord, which can pass appropriate order. So the order which they were relying also, my lord, in all the order, my lord, the parties were approaching MPERC, my lord. Our difficulty was that, my lord, since there was no clear guideline that who will decide this particular issue. So it was MPERC which was passing this particular order. The writ petitioner never approached MPERC for undertaking this particular process.
Meter which you have installed in there.
There is no meter, my lord. Because what they have done, this is.
You are issuing the bill.
No, my lord, we were not issuing bill to these persons. They were independent generator, my lord. They say
They are consuming 100%.
my lord, they are claiming,
They are not purchasing any
my lord, they are claiming this, but
dependent on
my lord, they are
production.
my lord, they are definitely, my lord, claiming this particular fact, my lord, that they are having, they are consuming their 100% of generation, my lord.
So then where is the issue?
But my lord, there is a statutory requirement of verification of the capital. Pardon.
Go and serve their premises and then raise a demand.
My lord, my submission is other.
When they are 100% consuming their generation, then there is, where is the question of?
My lord, I rephrase my argument, my lord. Claim is different from verification, my lord. The issue here is, my lord,
Data to dispute their claim.
my lord, my submission is that, my lord, we do not, in 2019, my lord, we do not have any authority to undertake this particular verification procedure.
They challenge the rectification.
My lord, they are challenging P23, my lord.
P23. Let's read.
My lord. This has been made impugn, P23. This is at page number 329. रिटेल टैरिफ ऑर्डर के अनुसार कैप्टिव पावर उपभोक्ता को छूट का लाभ दिए जाने के विषय में सो एंड सो विषय अंतर्गत मलट in fact mallard that has not been decided mallard that is mallard my issue is that mallard whether they are having captive status or not, this particular exercise is required to be undertaken, and for every year mallard they have not submitted any claim from 2021 onward mallard, but the writ court has granted a blanket protection to them.
Material to show that their production is reduced from 51%.
My lord, it is the question here is that, my lord, that we
are not here to decide that from.
My lord, my submission is that, my lord, there are two things. My lord,
my lord, do you have any data? We are not here to decide academic issues.
This is not, my lord.
Opinion and issue the notice.
My lord, P9 and P19 are two orders, my lord, which have other orders which have been placed. They have not made impugn to these orders, my lord. P9, my lord, page number 298. उपरोक्त विषय संदर्भित पत्र के साथ संलग्न परिपत्र एवं सहपत्रों के पालन में मेसर्स एसीसी कॉमर सो एंड सो कि कैप्टिव यूनिट का रिबेट देने हुए प्रस्ताव का सूक्ष्म परीक्षण किया गया। परिपत्रों की शर्तों के अनुसार मेसर्स सो एंड सो कैप्टिव आर्ताओं को पूर्ण नहीं किया है, अतः एसीसी कैमोर कैप्टिव यूनिट की रिपोर्ट की पात्रता नहीं देते, जिसके निम्नलिखित कारण ये है।
क्या मटेरियल है, क्या डेटा है, कितना प्रोडक्शन हो रहा है?
My lord, ये डेटा जो है, my lord, these data are required to be submitted by the generator, my lord, claiming themselves to be captive. My lord, that is the thing. There are two types of data, my lord. We will be verifying the data with respect to the reduction of their consumption, my lord. For captive generation, my lord, for their status of captive generation, there has to be authority, my lord, which will decide that they are captive generator. Every year they have to get a declaration that, my lord, they are captive generators. And once there is a declaration, my lord, we will give that particular rebate, my lord, unless until they have a certificate to that effect, my lord. It's like, I give a hypothetical situation, my lord, that if a particular person is claiming that, my lord, he belongs to particular caste, there has to be caste certificate which is required to be issued by the competent authority. And on the basis of that certificate, every benefit will be granted. Here, that certification was.
Certificate is not issued mechanically.
My lord. Definitely, verification. Now there is an authority which is prescribed for the verification, my lord.
But there is no authority in your group.
So if there was no authority up to 2023, my lord, that verification was done case to case basis after the approach and
to the government and make a law for that.
My lord, that law is there, my lord. Now that law is there. Now the competent authority is SLDC, my lord, Chief Engineer SLDC. So my grievance is my lord. My lord, my grievance is not that, my lord, that my grievance to that order is limited to that effect where the court has made a declaration that they are captive user without verification of data. Now, unless and until they present the data, my lord, it is verified. This finding cannot be given that they are captive user. Kindly have a perusal of the impugn order, my lord. Para 43. Now, without presenting any data even before the writ court, the writ court arrived at a conclusion that they are captive user. I'm reading para 43. If the aforesaid proposition and settled proposition of law are applied to the facts of the case of the present case, then it is apparently clear that the petitioner is fulfilling all the requisite captive rebate requirements for captive rebate scheme. Now, there is no verification of their captive status, my lord. They have not submitted, even before the report, they have not submitted the data, my lord, that what was their yearly generation for all these years, my lord. And what they have consumed, they have not submitted data with respect to their ownership of 26% of that particular power plant, my lord. And
you don't have any material to dispute.
My lord.
You don't have any material. The report has rightly observed that your entire case is based on the legal opinion.
My lord,
total non-application of mine.
My lord, I am.
Read para 53 and 54.
My lord.
You don't have any material to dispute their claim.
My lord, I am reading 53. After going through the aforesaid case, it is apparently clear that the law mandate the authority exercising quasi-judicial function must act with an open and unprejudiced mind. Whether the authority has already made up mind, the subsequent proceeding become empty and futile formality, as has been done in the present case. It is a specific case of petitioner that there is no application of mind by the authority, nor the relevant provision under the Electricity Act or rules have been taken note of by the authorities prior to denying the captive rebate to the petitioner. It is solely based upon legal opinion of their senior counsel. This is their submission, my lord. After going through the facts of the circumstances of the present case, as well as the judgment cited herein above, the court has no hesitation to hold that the petitioner is supplying electricity for the establishment situated within its township for the use of staff and other persons which are included in the generating unit of the industry. Now, this particular finding is not based on any data, my lord, which was presented before the report.
They are not purchasing electricity from you. That means they are consuming 100%.
My lord, my submission, my lord, we have a practical difficulty, my lord. Now, once we are giving a rebate, my lord, we need every month's generation data for the base year, my lord. Now, unless and until that data is there, my lord, there is a blanket order which has been provided, my lord, to give them rebate, my lord, and also, my lord, give them interest at the bank rate, my lord. Now, 2021, we have rejected their claim in the year 2021, my lord. They are approaching this honorable court in the year 2024, my lord. And this particular order has been granted to give the rebate, my lord, without any data, without undertaking any exercise. My submission is that, my lord, even if their petition was required to be allowed, my lord, it was required to be remanded to the competent authority for verification of all the data and statistics, my lord. Because there is a specific, my lords can have the how this rebate is required to be calculated. There is a formula prescribed where we need every month's generation of this particular generator, which is not there. No, my lord, my difficulty is that, my lord, once they undertake this particular process, my lord, all this data will be verified and factified by the competent authority.
How they can claim a rebate without submitting a detail about consumption?
My lord, that consumption, my lord, there has to be verification of that particular consumption, my lord, and generation. Because, my lord, kindly see the formula which is prescribed, my lord. The formula is, they have...
Are you disputing that?
My lord, we don't have...
Full material.
My lord, we don't had a verified data, my lord. If they... If, my lord, there is an authority... My lord, there is an authority prescribed to undertake this particular process, my lord. It is not...
You can also go through that.
My lord, it is them who has to undertake that particular process, my lord. The DISCOM will not go before that particular authority, my lord. They have to first get their captive status declared, my lord. And thereafter they have to approach us. That is our case. My lord, rules ये है, नया rules जो है, नए rules आप देख लें. Annexure A3 देख लें. Annexure A3 देख लें. my lord. उससे पहले की ऑर्डर सीटों ने भी रिलाई किए हैं. My lords can have 3.2 of this 2023 regulation, which is at page number 84. Verification of condition of not less than net 51% consumption by captive user. The net energy generated for the unit identified for the captive user shall be the gross energy generated for the unit less aggregate auxiliary consumption during 15 minutes of time block, and the energy generated in all the time block of the year shall be grossed upon for determining the gross net generation of CGP.
You rejected their claim in 2020 by an except P9.
2021.
What happened thereafter?
They have not challenged that order, my lord. Even that order is not made impugn to this petition also, my lord. P19 is the second rejection order, my lord.
16 November 21.
This is 16 November 21, my lord. And their claim was restricted only to 2 or 3 financial years, my lord, up to 2020-21, my lord. Their claim before us was submitted only to up to financial year 21, my lord, 2021, my lord. For 22, 23, 20. The current status, my lord, every year this scheme is extended, my lord. So they can definitely apply, my lord, and can get the rebate.
Whether they are getting or not?
No, my lord, they are not getting so far because their captive status is not verified so far, my lord. They have not approached. Pardon, my lord?
Every year you are required.
Every year, my lord. Because there is a SLDC chief engineer. SLDC is required to verify their captive status, my lord, with their generation data and working out the formula.
They are not party before this court.
SLDC not.
No, SLDC was not made party before the writ court, my lord.
3.2.3 says he is required to give the
So did you raise this objection before the writ court?
Specific that is not recorded, my lord. But my lord, that exercise is.
You should have called that authority before the writ court.
My lord, that should be properly done, my lord. But my lord, in any case, my lord, their matter, even if their petition is allowed, my lord, their case is required to be remitted to SLDC, my lord, for the purpose of this particular verification. And then only, my lord, the rebate can be extended. We are not against the rebate, my lord.
This objection before the writ court.
But so far as their suitability is concerned, my lord, that objection was raised, my lord.
It's not for you to decide. According to you, someone else is required to.
My lord.
They were not heard.
But they never approached to that particular forum also, my lord.
Yes,
Wait, please, Lord. I'm led by senior when we come in.
Yes.
Make the submissions. May I please, my lord? May I seek a lordship's kind permission, my lords, to address on behalf of the respondent, my lord?
Yes.
My lord. Firstly, my lords, my friend's entire argument is fundamentally wrong on facts. Even in my original application of 22nd of June 2019, which your lordships will find at running page 269, my lords, which is annexure P3. Kindly just have my original application, my lords, which was under the tariff order of 2018. This is my application of 22nd of June 2019. Kindly see the second last paragraph at the bottom. We are enclosing captive power generation data along with copy of electricity duty paid challan copies for each month and grid consumption details for the corresponding month. Every single piece of data, my lords, has been with them from day one. I will show at least half a dozen letters, my lords, for your lordship's kind consideration. Every single piece of data was there. I will take a lordship through the other letters in a moment. The second point, my lords, the learned friend argued, is that I have not fulfilled the requirements, the twin tests of Rule 3, which is the 26% and the 51%. Factually, my lord, at no point of time has the appellant ever disputed that the fulfillment of Rule 3 is not made. They had all understand, my lords, that yes, I was captive under Rule 3, but I ceased to be captive only because, according to them, I was supplying power to somebody other than myself. That was the only contention ever, my lords. at no single point of time have they ever disputed that I did not consume 26% and 51%. Kindly see notes before that. So on this 22nd of June 2019 is my application. I gave the data. Your lordships will see at page 270 at the bottom, just below the signature, you'll see copy of electricity billing made and as connection to summary of CPP generation, that is captive power producer generation, 1819, along with electricity duty paid challan, grid consumption details for SC number so-and-so for 1819, carry forward for relevance so-and-so. On the next page, so 29th of June 2019, by which the superintendent engineer, Malods, specifically said I am eligible for the rebate under the captive order. I will request your lordships, Malods, to have that letter at page 271. And it says, in response, the Chief General Manager, Commercial so-and-so, so-and-so, issued the following directions. And at the end of that extract, it says, shall be eligible for rebate as captive power plant consumer.
Yes.
Pursuant to this letter which was given to me, my lord, I applied to them to increase the load to be taken from them and to reduce my load correspondingly. Because the entire issue was they wanted to incentivize captive power plant to take more power from the DISCOM. So if I took more power from the DISCOM, they would be giving me a rebate of this 2 rupees for whatever is the additional that I took from the DISCOM. That was the entire scheme. So I reduced my own generation and started taking consumption from them, for which I took an enhanced sanction load in order to avail this rebate. That is my next letter, which I had sent at page 284, where I applied for the sanction load. They granted me the enhanced load generation in order to take more power from them and to avail this rebate under the scheme. This was allowed to me. So acting upon that presumption, my lords, I reduced my generation and started taking enhanced power from them. In 2021, 2 years later, they never gave me the rebate. I had to keep paying at the full rate. In 2021, for the first time, my lords, may I just take a look before 2021 to the 26th of February 2020 letter, which my friend relied upon at page 298. In this, my lord,
Yes.
in this letter, they said the captive power plant so-and-so does not satisfy the required conditions and no approval has been granted. During physical inspection, it was found that generators installed for captive plant are connected to the grid from the generator side, etc. And they said, considering the fact so-and-so, you do not fulfill the requirements for captive status. This was reversed on the 10th of June 2020. Your lordships will find 2 letters of 10th of June 2020. One is at page 301,
Yes.
which is annexure P12. And your lordships will see, this is been written by the superintendent engineer to the chief engineer, specifically saying that the rebate on captive unit may be granted in accordance with the applicable regulations. Copy of the prescribed Form G are enclosed. Form G is a form where I have to give details of every single unit generated, every single unit which is consumed, and by whom. I will take a lordship through this Form G for a minute. All the Form Gs were filed with them, my lords. They had full access to the data. They considered the data, and then they said, grant me the rebate. Then kindly see, my lords, the second letter of 10 June, which your lordships will find just 1 page earlier.
Yes.
Which was written, my lords, by the chief engineer to the general manager, commercial and billing. And where they said, please give, sorry.
Which of them?
Yes.
My lord. Now, these two letters of 10th of June 2020 are specifically noted, my lords, but
So father, your problem is that they are using the electricity, consuming the electricity for their residences, for their employees and that, and they are not purchasing from.
That, my lord.
So that you are not treating as a captive consumption.
My lord, that was one of the objection which was,
The main issue.
that was one of the objection, my lord.
So you are saying it is a.
My lord, my lord, in this writ,
Employees,
my lord, in this writ appeal, my lord, that part of the order is not under challenge, my lord. We are not saying so, my lord. Our grievance is that, my lord, we are
supplying this electricity.
My lord,
in their township also.
my lord, this particular fact, my lord, this particular fact, my lord, we are not the competent authority to verify those data, my lord, what they have submitted to us, my lord. The competent authority is, my lord, at present, my lord, Chief Engineer SLDC, my lord. Prior to that, it was, my lord, the Chief Engineer of the, my lord, it was held in 2024, my lord, that we can also do it. When they have applied in the year 2000, my lord.
Yes, sir, continue.
Second thing, my lord.
Let me reply.
My lord.
Yes. So आपने
Hello.
बता दिया होगा.
My lord.
Yes, please continue.
hold on. Both these letters of 10th of June 2020, my lords, are specifically referred to. In fact, they are extracted in extenso, my lords, in the judgment of the learned single judge, which your lordships will find at running page 53,
Yes.
para 28. And it is on the basis, my lords, of these two letters that the learned single judge concludes that yes, my eligibility to get the rebate has been accepted by these very authorities. At no point of time, my lords, has this ever been resiled from. In 2021, they, my lords, now want to take a U-turn and say, kindly see the letter, my lords, by which they say that I no longer get the benefits of a captive plant because I am, according to them, selling power or supplying power to people other than myself, which according to them is an education institution and a bank, etc., which is within my township. It is all within my township. It is not, my lords, in excess third party. I don't take any money from either the bank or the movie theater or anybody else for the supply of energy, because this is all within my township. And this is all for the staff, my lords, which is living in my township, which is working at the generating plant and the cement plant. Now, kindly see, my lords, the letter by which on the 27th of January 2021, by which they want to deny me the benefits of a CPP. Kindly see that letter, my lords, which your lordships will find at running page 312, which is Annexure P16. And this is the first time, my lords, that the denial is in place, which I have challenged in my writ petition. I will take your lordship through my prayer in the writ petition in a moment. It very categorically says that they conducted, my lords, a physical inspection of the plant, prepared an inspection memorandum, etc., etc. And they say that this power is being utilized by the following establishments: Educational Society, DAV School, Bank of Baroda, post offices, mobile towers. You request to provide information and supporting documents regarding the above institution establishments indicated under which rule, terms, or approvals the generated plant is being supplied to them. At no point of time, my lords, did they say, I do not qualify the twin requirements of Rule 3 of 26% and 51%. I respond to this, and I categorically say at running page 313, which is Annexure P17. Kindly see the first response of 17th of February 2021. in response, I say, my lord, if your lordships would please to have the second paragraph. In this context, please note that we have a captive power plant of capacity 50 megawatts situated at Kimore. The said plant is
Captive use is defined anywhere.
My lord, it is defined.
Yes, my lord. Second,
It is defined under, my lord, the Electricity Act.
No, that is captive generation plant.
My lord.
yes.
Captive use.
Let's kindly have rule 3, my lord, if your lordships will permit, rule 3 of the electricity rules. But before that, my lord, may very well, I'll show this to your lordship, my lord, and then I will just take your lordships to the electricity removal of difficulties, my lord's fourth order, passed under section 183 of the Electricity Act, where the township and supply to the township, my lords, is deemed to be in law an integral part of the generating plant itself.
Captive user is defined, my lord. Under the rules, my lord. Rule 322 B. Captive user shall means the end user of the electricity generated in captive power plant, and the terms captive use shall be constructed accordingly. Explanation 1A. Have B.
And but in the Electricity Act?
Electricity Act, the only thing is that my lord, defined as captive generating plant, my lord.
For own use.
For own use, my
lord. Own,
that is the reason, my lord, why we have said for
myself for any purpose.
But my lord,
for the generation purpose.
My lord, what our objection was that, my lord, they were selling this electricity. There was a bank.
Restricted that electricity should be consumed only in plant.
51%, my lord, is for own use. For own use.
Own use.
My lord, that is. My lord, my objection, my lord, because that is very fractional of use, my lord. So my instruction is that, my lord. My objection is with respect to the verification process, my lord.
They are using electricity within their campus and not giving
My
to
lord.
any third person.
My lord.
That means it is own use.
My lord. That has been held by the report, my lord. But my lord, our challenge here is, my lord, with respect to the verification process, my lord. Now, unless until they certified it, my lord.
You are excluding their township part from the.
My lord, in rate appeal, we are not on that issue, my lord.
Then why you're fighting?
My lord, my lord, two question, my lord, two question will come up. My lord, their claim before the red court was limited only to up to year financial year 2021, my lord. There was no data which was filed for subsequent to that, my lord. 2022 से लेके 2025-6 तक उन्होंने कोई डेटा नहीं दिया।
Demanded that आपने demanded नहीं।
मतलब वो उनको रिबेट उनको देना मुझे देना है, उनको जो हमने बिल रेज किया है उसमें मंथली बेसिस में मुझे रिबेट करके रिफंड करना है। नाउ इफ दे आर नॉट क्लेमिंग दैट रिबेट, माय लॉर्ड, टू अस, तो उसमें कैसे वो मिल सकता है? They have not claimed it. They have not filed any document. And my lord, I have verified from the department also, my lord. Their rejection is of the year 2021, my lord. After 2021, they have not submitted any claim for this particular rebate, my lord, before us.
Should may kindly see para 7.5. Totally wrong, my lord. My friend is factually
There is
incorrect.
there, my lord, but there is no pleading. There is no pleading.
Kindly see annexure P. Sorry.
Once you have denied their status,
my lord,
then they are not supposed to submit.
my lord. So, my lord, there is a part of interest which is also awarded in this case, my lord. Not from 2021.
You are not treating them as a captive consumer.
My lord.
So that's why they are not submitting any.
My lord, but there is a belated.
Now the report has given a declaration.
My lord, even if
they will submit their details and claims.
My lord,
you may verify it.
My lord, verification process has. My lord, verification.
Mr. You entered into an agreement.
My lord,
treating them as a captive consumer. You enhance their capacity. And now you are thinking you are.
My lord, there is no agreement with them treating them to be captive consumer, my lord.
See the agreement body use है कि captive consumption इसके limit बढ़ाई जाती है.
My lord, that agreement has been entered in the year 2019, my lord, with respect to the enhanced, my lord. My lord, kindly have a perusal of 3 letters. My lord.
You are treating them as a captive consumer और उसकी limit बढ़ा रहे हैं.
My lord, by again, my lord, by
you treat them as captive consumer, then they will submit a data, then you will decide.
My lord, This particular exercise, Malad, this particular exercise is required to be done by SLDC Chief Engineer, SLDC, Malad. My prayer is that, Malad, it can be, Malad, second aspect, Malad, if Malad, even if Malad on merit, Malads are not inclined, Malad, the interest part may be considered, Malad.
Interest part?
Fixed, but there is a bank rate interest, Malad, which is awarded on the amount which is we are required to refund, Malad. Now there is a claim, they admittedly, Malad, for
the claim
2021, Malad, Malad, interest का order किया है court ने.
But claim कहाँ है? Where is the claim?
Malad, but the court has awarded it, Malad.
Claim तो बताइए कहाँ है जिस पे interest मिला है?
1900 उनको जो हमने rebate देंगे, Malad, we have to calculate it, Malad. Kindly have a perusal of the operative part of the order, Malad.
On record ना इनका claim है ना आपका denial है.
Malad, but there is an order, Malad, once we start adjudicating upon the process, Malad, कि इनका इतना refund बनता है. Malad, 185 crore की liability हमारे ऊपर आ रही है. That is the structure. They have made a claim. They have made claim before us, Malad, for 6 years, Malad. I can place that on record, Malad. And from 2021, my lord, they have not raised any claim, my lord. From 2021, their status has been rejected in their 2021, my lord, and they have filed urgent hearing application के साथ हमने claim दिया है. My lords can see. Urgent hearing application के साथ हमने claim file किया है इनका. इन्होंने जो calculation दिया है.
I can see para 8 of my early hearing application. There I have quantified till March 2026.
They have filed, my lord, along with their urgent hearing application. 108 crore का.
Yeah, if I may just interrupt your lordship's proceeding for a moment, my lords, in this respect, your lordship may kindly note the conduct of the appellant, my lord. The impugned order is of September 25, of October 25. They have themselves taken it upon themselves to stay the impugned order and not implement it today.
My lord, my learned friend is quite unfair with me because he is also aware about the fact that the order has been uploaded in the month of January 26, my lord.
So look, today we are in June 26. My friend takes it upon themselves to stay the impugned order, not move their appeal. I am the one, my lords, who moved an early hearing application and as a respondent in their appeal, my lord. They have not taken any steps to move the matter before your lordships, my lords. Can you see the conduct of the appellant?
My lord, so the interest part may be, my lord, that may be considered, my lord, because 6 to 2020 is, my lord, their first rejection order, my lord, which they have not challenged, my lord. In fact, in this petition, what they have made impugned is P23, my lord.
Challenge it for the first time.
Their first denial is 2020, my lord.
Yeah. May I also indicate that
we can say, my lord, that subject to verification, we will definitely, my lord, undertake that exercise, my lord.
May I only
we will
indicate
grant them rebate, whatever entitled, my lord. Interest part may be considered, my lord. I have instructed.
My lords, we have raised claims, my lords, in 2022, 2023, and 2024. All those letters, my lords, are on record before your lordships, my lords. Kindly see the first of the two letters as is Annexure P21 in 2023 also.
But you filed.
My friend is entirely incorrect to say that from 2021 to 24 we did nothing.
December 24, my lord. December 24.
But you filed a petition in 24.
Yes, my lord. Yes, my lord. Because in February 23 and all of it to March 24, again in May 24 it was rejected, and in June 24 again I raised the claim on them, and then I filed, my lords.
The interest part में क्या कहना?
No, I would respectfully submit. Kindly see the conduct of the appellant, my lords. They incentivize me to come and take power from them. I shut down one of my plants. I increase my enhanced load. I go to them and take power on the basis of the promise held out to me, my lords, that this 2 rupee rebate will be given to me. If this rebate was not offered to me in 2019, my lords, I would never have gone to them. I would continue merely with my own captive generating plant, which was Manoj, policy under the Act. They wanted this benefit, Manoj. I went to them and took this power. And today, Manoj, they turn around and say, sorry, on a very species ground, just don't want to give me the rebate. Can you see the conduct, Manoj?
There is a condition of delay application also, my lord, in this case, my lord.
Lordship, I seek to withdraw this writ appeal with liberty to file properly constituted.
Properly constituted.
Facts,
is already delay. Yeah, what is the problem in this?
Lordship, the facts of some different case has been mentioned, so that's it.
Copy cut it. Counsel for the petitioner submitted the typography there, wherein the appeal cannot be cured by the moment. He will be permitted to withdraw this appeal with liberty to file a question.
Always, Lordship.
My lord. Lord, the London Red Court had dismissed my writ petition solely on the ground of locus, my lord.
क्या मैटर क्या?
My lord, the petitioner has preferred a petition, my lord, against the Sarpanch regarding his previous involvement in the corruption, my lord. And as per the anexure P1 of the my writ petition, my lord, there was a clear stipulation regarding that if there was circular, my lord, 4.1, my lord, if there is any previous proceeding against the Sarpanch under section 40, 89 and 92 is pending, my lord, then the construction work of the Gram Panchayat shall be given to the rural engineering services under the supervision of Janpat Panchayat, my lord.
Who are you?
My lord, he is the elected member of the Panchayat, my lord.
Of which panchayat?
Gram Panchayat,
Panchayat or
same Panchayat. Same Panchayat, my lord.
So raise your voice in the general meeting.
My lord, that was done, but that's why no.
You are an elected member.
My lord.
You participate in the panchayat proceedings.
My lord, that was the issue, my lord. That's why we have.
The floor of your.
My lord, what has happened, my lord, directly this. My lord, what I am submitting is for the currently seen on example P1 circular. It's very much specific, my lord.
On the Panchayat Act, you will find the provisions and quorum also.
Sir, 4.1 बस एक बार देखने से उसमें very much वो that circular is very much specific.
If you come to the High Court directly, don't read Panchayat Act and rules. There are provisions. And despite punching, you don't know the provisions.
We are not against on that aspect that the work was allotted to Panchayat. We are on that aspect that it should be given to the rural engineering services as per the light of 4.1. That is only issue, not.
You are opposing your own Sarpanch. The petitioner filed this petition seeking direction to decide the representation. Next P3. P3 is not representation.
P, that is P4, my lord. Technical.
What is direction can be given and direct petition where the representation is not an statutory representation and the authority is not a competent authority under the Act and rules to decide such representation. The petitioner feels your petitioner is a locus and avail other remedy available in the Panchayat Act. This court has not submitted any letter. Like,
petitioner, the bus operator, and challenging the permit granting order before the writ court. The writ court has pleased to dismiss the writ petition with holding that the petitioner has no any locus to challenge the permit. whereas the which judgment has relied by the honorable single judge, my lord, it has the writ appeal number 806, my lord. May say page number 17. उसी में है मान लो thus the learned single judge had rightly heard that writ petition appellant had no right to be heard. If they were aggrieved, they could have challenged the same in revision under section 90 of the act, but they had directly approached this court, invoked writ jurisdiction under article 226 of the constitution, meaning they are one of the petitioner has right to challenge the permit before the revision authority under section 90. So liberty में the learned taken liberty, मान who has taken the liberty? Well, I am taken liberty. But who has taken liberty from you? You can go. Writ code has. But writ code has mentioned this the locus, particular locus. This locus to file a writ petition. But
There is an observation that 226 is
no,
not mentioned.
but my response
Yes, right.
may kindly be granted liberty. I withdraw the writ appeal. The liberty is there. Yes, opposing. May kindly restraining you. Only I will withdraw the writ appeal. Liberty to file the revision under section 90. But this particular sentence was the locus to challenge the permit. Where is the 806 which is relied by the land? There is no interpretation against the sentence. Mr. Counsel, we will both cost. You are reading only half of the sentence and saying that the liberty has been taken. Last, if the aforesaid principle is applied to the facts and circumstances of the present. Last end तक पढ़िए इसको. This is the last paragraph. Before this code, maintainable as the petitioners are having no locus to challenge the permit granted in favor of the private one in a petition in Article 226. What it means? Dismissal withdrawn. With liberty to file the. Petitioner counsel to understand the relief granted by the writ code and unnecessary insisting. And file is simple. Heavy cost simple withdraw the vote. Simple.
There are two cases. Yes. 14.
My lord, the learned single judge rejected my writ petition.
May I make a prayer, my lords? I'm praying for Basu.
Why?
Because the arguing counsel is not available. He's in other court to my lords.
Well, no notice has been issued to you, sir.
It may be.
For admission first. Yes, what is your view?
My lord, I filed writ petition claiming relief to remove encroachment done by railways on my land in Kasa number 1168/1 and suitable compensation from railway since they are using land since 1990. 1989 में हमने लैंड खरीदी, 90 में रेलवे ने अपने गिट्टी पत्थर. My lord, in demarcation proceedings, it is admitted fact.
Where? From which document you can prove that it's an admitted that they have installed your land?
डिमार्केशन रिपोर्ट है और ये रेलवे ने लिख करके दिया है कि जॉइंट वेरिफिकेशन करवाया जाएगा जब हमने उनको नोटिस दिया एनक्रोचमेंट का. और डिमार्केशन रिपोर्ट में एट पेज नंबर 73 में प्रतिवेदन है रेट पिटीशन में. प्रतिवेदन रेट पिटीशन पेज नंबर 73 सॉरी. मैंने 73 में प्रतिवेदन है जो दिया है पटवारी ने और आरआई ने तहसीलदार को, जिसमें इन्हें रेलवे के लिए संबंधित दस्तावेज के साथ उपस्थित रहने के लिए परमिट किया था और 1168 हमारा है, 1168/2 रेलवे का है. और माय लॉर्ड थर्ड पैराग्राफ में आया है तहसीलदार महोदय घोड़ा डोगरी दिनांक 20/6/25 के पालन में ग्राम घोड़ा डोगरी पटवारी हल्का नंबर 20 स्थित खसरा नंबर 1168/1 का सीमांकन के लिए राजस्व विभाग रेलवे विभाग मौके पर उपस्थित राजस्व नक्शा शीट और रेलवे के नक्शे का मिलान किया गया, जिसमें पाया गया कि रेलवे के नक्शा शीट खसरा नंबर 1168/2 और 1168/1 का जो नक्शा दर्शित किया गया वह राजस्व नक्शा शीट से मिलान नहीं होता. तत्पश्चात रेलवे से लैंड प्लान की प्रमाणित प्रतिलिपि उपलब्ध कराने के लिए कहा गया जो उनके पास नहीं था. तत्पश्चात राजस्व की नक्शा शीट को आधार मानकर आवेदित भूमि का सीमांकन डीजीपीएस मशीन की सहायता से मूल खसरा नंबर 1144 में स्थित रेलवे पत्थर सीमा मूल खसरा नंबर ये नंबर दिए. और
क्या कर रहे थे
जी मैंने
30 ईयर से क्या कर रहे हैं?
हमने 90 में फर्स्ट लेटर दिया था और माय लॉर्ड उसके बाद हमने अनेक बार कंप्लेंट की, मोरले में भी कंप्लेंट की।
थोड़ी मिलता है आपको, रेट में आना था, सिविल सूट लगाना था कंपनसेशन के लिए।
माय लॉर्ड इसमें
90 का क्लेम है तो आपका पोजीशन हो गया।
डिमार्केशन प्रोसीडिंग्स तो फाइनल हो गई, उनने कोई ऑब्जेक्शन नहीं लिख, पंचनामा में ऑब्जेक्शन लिखा लेकिन एसडीओ क्या नहीं गए।
For 30 years we have not filed any petition.
फाइनल जो रिजल्ट जो है
Court has dismissed the petition only on the ground that you 30 years you.
A2 ऑनरेबल सुप्रीम कोर्ट का ऑर्डर लगाया है मैंने एक केस में A2 में 17 से 23 पे रेट अपील में। इस कोर्ट में माय लॉर्ड
30 years।
जी माय लॉर्ड, बीच में वो गेट लगा रहे थे, हमने ऑब्जेक्शन किया तो उनने गेट रिमूव कर दिया। और माय लॉर्ड सेक्शन ऑनरेबल सुप्रीम कोर्ट ने इस केस में विद्या देवी वर्सेस स्टेट ऑफ हिमाचल प्रदेश में AIR 2020 सुप्रीम कोर्ट 4709 में ये डिसाइड किया 45 साल के बाद भी लैंड एक्विजिशन एक्ट के तहत कार्रवाई की गई, कंपनसेशन भी दिया। एनक्रोचमेंट के बारे में है माय लॉर्ड ये वाला केस। इसका ऑपरेटिव पैरा में पढ़ देता हूँ। राइट टू प्रॉपर्टी इज
इसमें रिप्लाई आया था क्या?
जी मैम,
रिप्लाई फाइल हुआ था?
नहीं रिट में रिप्लाई फाइल
नहीं हुआ,
रिप्लाई नहीं
फाइल है, नोटिस एक्सेप्ट नोटिस रिप्लाई नहीं फाइल। ओके yes
my lord, the matter in brief is that my lord, the petitioner had filed an application under section 178 before the Tehsildar for partition, my lord. The Tehsildar had rejected my application. Thereafter, we filed an appeal before the SDO, and now, my lord, the appeal is pending before the SDO since 2024. Now, my lord, for the expeditious disposal of the appeal, my lord, the petitioner is approved before this honorable court by filing the writ petition, my lord, 5957/2026. Now, my lord, the writ petition was finally heard on 27/2026 and dismissed by imposing a cost of rupees 10,000. And the Honorable Writ Court has observed that the litigation filed by the petitioner is frivolous on the ground, my lord, that on the two occasions the petition has not appeared before the learned SDO. My lord, may kindly see the order sheet, my lord, lower court record. Lord, because my lord,
डायरेक्शन नहीं आएगा और वहाँ appear नहीं होगा।
no, my lord, may kindly see the lower court record annexure P3, my lord. There is, my lord, my appeal is pending since 2024 and there is apparent delay on the part of respondent number 2 for deciding my appeal, my lord. That's why we have approached before this honorable court for deciding the appeal, my lord. क्योंकि इसके पहले हम अपेयर हो रहे थे कंटिन्यू, पर पोस्टपोन हो जा रही थी पोस्ट डेट की पीठासीन अधिकारी मीटिंग में व्यस्त, फिर प्रकरण पेश, फिर पीठासीन अधिकारी मतलब इसके बाद वी हैव फाइल्ड दिस रिट अपील, my lord. अभी इस अपील इज स्टिल पेंडिंग, my lord. They have not decided, my lord. My lord, the petitioner is old age form, my lord.
Are you appearing there?
My lord. Yes, my lord. Appealing, I am appearing before the STO, my lord.
Just on the order sheet. है आपके पास?
लोअर कोर्ट रिकॉर्ड में लगा हुआ है एनेक्सर पी।
होगी, वो तो कोर्ट ने कंसीडर कर ली, फरवरी के बाद की बताइए।
उसके बाद की ऑर्डर शीट्स नहीं है, बट 4/3/26 को अपेयर होगा।
So you have bona fide that you are regularly appearing and still the SDO is not decided.
I will file.
देखिए आना चाहिए अगर आपको कॉस्ट रिमूव करानी है। क्या रेवेन्यू अपील है क्या?
हेलो,
डिसाइड कर लीजिए भाई। कॉस्ट को कम कर देते, 5,000 करते।
my lord, petitioner is farmer, my lord, too old age person, my lord.
तो बड़े लोग भी होते हैं।
60-year old age person है, my lord. They are poor, my lord. They have no any source of income, my lord. मैं humble submission, my lord.
रेट पिटीशन लगा दी, रेट अपील भी लगा दी और कह रहे नो सोर्स ऑफ।
हमने कोई
से लगाई क्या? लीगल एड ली थी क्या?
नो my lord, हमने कोई इनसे फीस नहीं ली।
You can afford to pay the cost.
My lord,
नहीं होती तो हम लीगल एड से वकील देते।
मैं humble submission, my lord.
रेट अपील लीगल एड से लगानी थी।
My lord,
चलिए,
कॉस्ट को कम कर देते हैं my lord.
let the SDO is directed to decide the appeal as to details preferably within period of a week from the date of protection of certified copy. Keeping in the ever made in direct petition as well as mandate of the cost is reduced from 10,000 to 5,000. Next.
My lord, in this case, I have challenged the order whereby my application under section 29A of Arbitration Act has been rejected by the commercial court, saying that the court has no jurisdiction. Whereas, my lord, I have uploaded the latest apex court judgment, which says that the lower court is the principal court as per 2E. Therefore,
What you think of it?
I'm sorry, subordinate trial court. My lord, I'm sorry.
Civil court बोलिए.
Civil court. I apologize. I apologize. Civil court, as per my lord 2E, the civil court is the principal court. Therefore, if my lord will appreciate the judgment which I have uploaded, my lord, that is reference 1.
Reference में है?
Yes, ma'am.
We have also uploaded the judgment.
Reference में नहीं. क्या application of section 29?
Yes, my lord.
29A.
And in fact, my lord, the entire proceedings are over. Only it is final arguments and award has to be pronounced. Remaining cross examination and everything is over. So the extension of time, if 6 months are granted or 3 months, it will.
Yes, my lord, the commercial court has relied on the judgment of this court of year 2024, but the latest judgment is of Honorable Justice Narasimha in the case of
It is
Chogle.
2026 SCC online. Yes, ma'am. Chogle.
कितना टाइम चाहिए?
My lord,
यहीं से extend कर देते हैं क्या बात?
yes, my lord, that will serve. My lord, honorable, 3 months will be sufficient.
Yes, Mr. Jain.
Yes, ma'am.
Taking with the consent of party and relying on a judgment passed by apex court in case of 2026 FCC online FC 124, the ensuing order is taken so it is required. The learned arbitrator is hereby granted 3 months time to decide the arbitration, conclude the arbitration proceeding.
Deeply obliged.
Midway through an ongoing contract, the respondents have issued impugn SOP, which amounts to altering terms of the contract. Now there is bunch of about 10 petitions which has been entertained and pending. They are coming up on 2nd of July. The orders I have uploaded, madam. WT 23563 of 24.
Payment.
Same.
Same order.
But I'm appearing for 2 and 3, my lord, in this matter.
Yes.
Okay, much obliged.
19.
आवेदक माननीय उच्च न्यायालय प्रधान के समक्ष निवेदन करता है। माननीय राज्य आयोग और राष्ट्रीय आयोग को निर्णय लेने से पूर्व यह देखना चाहिए कि दस्तावेज रिकॉर्ड में होने के बावजूद भी आवेदक द्वारा
करने आए और तो हम भी लेंगे।
जी सर।
आपका अपना केस है ना?
जी सर।
तो याद होना चाहिए आपको।
जी सर।
तो पढ़ने की क्या जरूरत? क्या मामला है बताइए, ऐसे बताइए।
सर केंद्रीय विद्यालय में फॉर्म दिया गया था, वो वापस हो गया था। 13 तारीख को, तो लिफाफा वापस हो गया।
पोस्टल से?
वो स्पीड पोस्ट से लिफाफा भेजा। नहीं, वो वहां दिल्ली गया ही नहीं, उसमें ना सील है, ना साइन है, ना हस्ताक्षर थे। लिफाफे में तीनों चीज नहीं थी, चारों, और ना ही नोट लिखा हुआ था।
किसके एडमिशन के लिए भेजा?
केंद्रीय विद्यालय सारे शिक्षक की पोस्ट के लिए।
पोस्ट के लिए, अपॉइंटमेंट के लिए भेजा?
जी सर, सारे शिक्षक की पोस्ट के लिए भेजा। सर 13 साल हो गए।
उसके बाद और पोस्ट नहीं निकली कभी?
सर बाद में तो निकली नहीं थी, ओवर एज हो गया था ना सर मैं।
13 साल से और कहीं नौकरी नहीं मिली?
नहीं सर।
वकील बन गए क्या?
सर LLB भी कर ली सर, LLB भी कर ली।
अरे बहुत अच्छा किया बेटा। भगवान ने आपके लिए कुछ और सोचा था।
जी सर।
मिल गया आपको, खत्म करिए मामला। अपने केस लड़ेंगे तो दूसरे का कब लड़ेंगे? चलिए हो गया खत्म।
सर 25,000 रुपए दिए हैं उसमें।
बहुत है, काम आएंगे। लाइब्रेरी खरीदिए,
सर
खरीदिए, वकालत में काम आएंगे।
सर मैं कुछ बोलना चाहता हूँ उसमें।
अरे हो गया, सुन लिया
सर बहुत कम है सर।
ठीक है 25,000। चलो, नौकरी की कोई गारंटी नहीं होती। फॉर्म पहुंच भी जाता तो मिल जाती क्या?
हैं?
फॉर्म पहुंच भी जाता तो मिल जाती नौकरी।
सर साल भर से तैयार, मैं पहले मैया सीमेंट फैक्ट्री में था ना सर, पहले मैया सीमेंट सेक्शन असिस्टेंट की पद पे था मैं।
अच्छे वकील बनिए।
सर मुआवजा बहुत कम दिया गया है।
इस देश के, सुनिए, सबसे बड़े वकील तो नानी पालछा वाले थे।
जी सर।
उन्होंने प्रोफेसर के लिए इंटरव्यू दे गए थे।
जी सर।
फिर नहीं हुआ तो वकील बन गया, फिर सबसे बड़े वकील बन गए।
सर मैं कुछ बोलना चाहता हूँ।
फिर पीछे बहुत लोग बैठे हैं।
जी सर।
यार बहुत 25,000 किस मिल जाते हैं? Welcome to this profession. Thanks.
My lord, in this, the grievance of the petition is very limited, my lord. In the persons of the direction given by this honorable DB, my lord, he made a complaint to the public land encroachment cell. Complaint was made, my lord, but till today it has not been decided. So we have a only limited prayer that the collector may be directed to decide the complaint regarding the encroachment on a government land, that is a hospital. So my lord, that may be.
इस काम के लिए दो पिटीशन, उसी पिटीशन में टाइम लिमिट क्यों नहीं फिक्स कराया?
My lord, in fact, the P6, my lord, may kindly.
इसमें तो withdrawn हुई है उसके।
हाँ, with liberty, my lord, that to approach before the public.
एक बार में पूरी रिलीज ले लिया करिए, बार-बार कोर्ट का टाइम
My lord, certainly that is.
उसी में लिखवाना था।
My lord, I.
Petition is not contained.
No, my lord. So my lord, we made a complaint that the dispute is not here, and my lord, like this. My lord, may please to only my concern is only, my lord, to the extent that a collector may be decided, my lord, my complaint may be decided, and either way, whatever he has to do. But at least he should decide. P7 is the complaint, my lord, which the recent has been given in the pursuance of the order passed by this honorable court. So my lord, only it may be directed to be decided within 3 months, 2 months, my lord, whatever may timeline. He may decide, my lord. It is a mandate of that particular protection cell to decide, my lord. But they are not deciding, keeping it pending from the last.
Land protection cell.
Yes, yes. My lord, in 2023, it was constituted and the power has been given to the SDM collector with regard to the exercising the particular power.
कहाँ का collector है?
And that is, my lord, district Raisen.
हो जाएगा।
My lord, with due respect, and my lord, I am not seeking any adjudication on merit, my lord. I just have a little bit grievance, my lord. It may be decided in either, my lord, whatever in accordance with law. So 60 दिन में, my lord, ये decide कर दें।
Proper applicant तो जिसके खिलाफ एलिगेशन लगा रहे हैं, तो respondent नहीं बना रहे।
बनाए। Sir, R5.
P7 देख। कलेक्टर को जो एप्लीकेशन।
हाँ, my lord, ये लिखा।
एप्लीकेंट नॉन एप्लीकेंट बच्चे नोटिस जाता है, केस रजिस्टर होता है।
My lord, that is the collector. My lord, in fact, it is nowhere in the prescribed procedure for filing of appeal like that. But
make a complaint in a prescribed format, which is applicable for civil.
My lord, in fact,
जिसको आप एलिगेशन लगा रहे हैं, जिसके खिलाफ एनक्रोचमेंट का एलिगेशन।
My lord, there is a demarcation report here on the record. Wherein demarcation, it is clearly been found that he has constructed. My lord, may please to see if I may be allowed to read that particular. The patta was granted. My lord, may please to see P1 page 15, ma'am. In this, my lord, a demarcation was conducted amid of the part. सीमांकन में पाया गया खसरा नंबर 814 अस्पताल नजूल की भूमि पर 0.046 सेक्टर में 10 से 15 पूर्व वर्ष के मकान बने हुए, जिसमें नक्शे में इट इज अ गवर्नमेंट हॉस्पिटल लैंड, माय लॉर्ड।
अपॉर्चुनिटी ऑफ हियरिंग तो देना पड़ेगा।
हाँ, certainly. So my lord, he will issue the notice. My lord, the collector may not. My lord may observe this thing कि after hearing both the parties may pass an order in accordance with law.
एक बार में पूरा ऑर्डर लिया करिए उसको।
Next time, my lord, I will.
21.
My lord, any timeline may be given in that particular.
My lord, this pertains to the rules. I have been levied fine of about 97 lakhs. 97 lakhs. On an allegation.
ये DB2 में है, माइनिंग मैटर है।
जी, वायरस चैलेंज।
वायरस? काय का?
of the rule.
क्या प्रॉब्लम है?
पहले वायरस बता दो,
हाँ
फैक्ट्स बता दो.
अगर वायरस नहीं है तो फिर सेकंड 3 में जाएगा, DB2 में जाएगा.
जैसा आप कहें.
नहीं वायरस पता है क्या है? प्रॉब्लम क्या है?
Mal. The rules framed are,
लगा है ना?
yes, these are the rules known as Madhya Pradesh Mineral Prevention of Illegal Mining, Transportation and Storage Rules, 2022. These rules have been framed, volume number 26, madam. 26 and 25 दोनों लगेंगे. Sorry यार, देना था पहले. That's a twofold submission. One is lack of competence of the legislature. मैडम 26 भी लगेगा, 25, 26 तो वो लगेगा.
अरे जो रूल को चैलेंज कर रहा है वो एनेक्शन नहीं बनाया.
किसको सर?
जिस रूल की वैलिडिटी चैलेंज हो तो एनेक्शन नहीं है. इसमें देख ले.
तो मैंने वो कोट किए हैं,
कोट किया है,
फाइल कर देता हूँ.
चल बताइए.
तो मैं फाइल कर देता हूँ.
रूल नंबर
सर रूल जो है वो मैं बाद में आ रहा हूँ 18-19 पे. फर्स्ट इज दैट दीज रूल्स हैव बीन फ्रेम्ड अंडर सेक्शन 23(3) ऑफ द माइंस एंड मिनरल्स डेवलपमेंट रेगुलेशन एक्ट 57. वो उसके लिए वॉल्यूम 25 देखना पड़ेगा. वॉल्यूम 25. वॉल्यूम 25 में इट इज पेज नंबर 106. These rules have been framed under this Act of 57.
Yes.
23(c).
Oh, yes.
23(c).
Power of state government.
Yes. 23(c). May by notice in the official gazette make rules for preventing. So it starts from here. Important from here. Illegal mining, transportation, and storage of minerals. These are the three things. Now, in particular with respect to the indemnity of so-and-so established checkpost so-and-so. Now, what it says is A to Z. A to G में जहां तक आप आएंगे, अब ये जो रूल फ्रेम किए हैं इनने इसमें एनवायरमेंट कंपनसेशन लगा दिया. 47 lakhs is the calculated amount of penalty as per the rules. मैं उस पर बाद में आ रहा हूँ सर. And for double the amount is towards the environment compensation. That they cannot. There is an environment act of the central government which will fall under the central government parliament's jurisdiction. Under this rule, they cannot impose environment compensation for environment for pollution. इसमें environment नहीं आता सर. Now kindly see the rules, sir. 18 में आ जाए सर, rule 18 में आ जाए. Sir, rule 18. Sir, 18(2) में आ जाए सर. Determine exterior so and so, party so and so, contravention of provisions, then you may compound the offence. नहीं, इसके ऊपर आएगा सर. Mining transportation shall be presumed. Violator amount, the last 3 lines of 18(2). Amount equivalent to the fine shall be imposed additionally in form of environment compensation as penalty. This part I am telling you, sir.
It is beyond competence.
Yes, this is one. इसके अलावा rules में भी जो है article 14 and 19G are involved. There are 2 rules, one for transportation and one for illegal mining. इसके अलावा factual aspect में भी I have a case. On the factual aspect also I have a case. एटीन में आप देखेंगे सर, this is one aspect. 18 में आप देखेंगे sir, they say that if it is compounded, they'll give me a notice. If I wish to compound, I'll pay 1,000 rupees fees and then compounding. Now here what 18 is for illegal, whoever is found storing, illegal extracting, storing, extracting or storing, or on whose behalf extraction and storing is being done. The storing is the word. Transportation would be, I say, synonymous of storing. Transporting would amount to, would be something like synonymous of storing. Now 19 pertains to transporting illegally extracted material. Now, on the contrary, transportation would include extraction and storing both. 19 में आएगा. Now there is a difference between both. 19 में कहते हैं कि हम आपका मिनरल भी छोड़ देंगे, अगर आप कंपाउंडिंग फीस देंगे, गाड़ी भी छोड़ देंगे, विल लीव एवरीथिंग. और 18 में कहते हैं हम सिर्फ आपके जो टूल्स हैं वो देंगे, गिट्टी फावड़ा दे देंगे आपको, मिनरल नहीं देंगे. One is this difference. A person who's transporting his vehicle will be also released and illegally extracted. Mineral will also be released. There are a number of other also, sir, that here they say, I just read it, sir. If you are transporting, then maximum amount of environment tax जो लगा रहे हैं, that is 4 lakhs. And if you are illegally mining, then in proportion to that.
ठीक है, वायरिंग का जो फाइल मतलब
Sir, 97 lakhs recovery. On factual aspect, I have a good case. एक लाइन दिखा देता हूँ मैं आपको, सिर्फ एक देख लें. Now this provision 18 and 19 के बाद लिखा जरूर है, 23 देखिए सर. What 23 says? The way of investigation. In this case, I have a pit. I have a mining lease in my field. I'll just show that document to my big mining lease. I am conducting mining. My crusher is there. My crusher is there. Now, when my crusher is there, what they say कि आपकी mining के area के बाहर 20 मीटर दूर एक पिट खुदा पाया गया, वहां 20 बोल्डर करीब बोल्डर पाए, इसीलिए हम presume करते हैं कि आपने खोदे. Presume. The word used is in 18. The word used is any person is found extracting or storing. मैंने अपने घर में store नहीं किया. I have, and that has not been given to me. It was found there. किसी गड्ढे में something was found. तो say कि because आपके पास में है, therefore we presume. Now what 23 says, kindly just appreciate 23. Nothing has been done. If it is found involved in illegal extraction, illegal mining, so and so, mining officer to initiate illegal extraction, prepare a panchnama. Panchnama बनाया, हम बताते हैं panchnama कैसे. I'll read that. Now, may include videography. There is no videography.
Final reply, we consider your interview.
Sir, 97 lakhs.
On the
97 lakhs.
Otherwise, you have a remedy of appeal. You are bringing this matter before this court by challenging the wiring. Wiring you can deal just now.
On an earlier round, the petition was withdrawn.
Because they have a power to do anything to prevent illegal mining. They can impose a heavy fine and under the head of it. Hey, reply. Next.
22. Some weak comments.
Just immediately after 5 minutes.
So immediately after 5 minutes, I'll be under mercy. Sir, वो execution कर देंगे sir. और ऐसे जुलाई में लगा दे second week में. थोड़ा उन पे pressure रहेगा तो जल्दी जवाब आ जाएगा. जल्दी second week लगा दे.
Yes, next week.
The matter regarding GST on the royalty on the limestone, the identical matter already part. Bunch of matter is still pending.
Royalty. Same order.
ERP में approved.
हाँ.
So these are the matters pertains to the, we are telling the order passed by the Honorable Red Court, ma'am. The notices, well, there is a delay, notices were issued, my lord, this has to be heard finally, my lord. I'm just praying a short time to prepare the synopsis. It's a matter of sealing, my lord, sealing matters, my lord.
Matter of sealing.
Sealing, my lord, urban land sealing act. Record is also there, my lord, in one of the matter, my lord. So we have called that record also. That is there in the office, my lord.
We can rate appeal.
Writ appeals, my lord. We have challenged the order passed by the Honorable Red Court, whereby their petitions have been allowed and the proceedings of sealing has been set aside by.
They were to comply with the order dated 25 February.
We have complied. Well, we have made them the, oh, that in support of application. My lord, that also, my lord, we'll. They have
1700.
1477 days till yet. We'll file the additional affidavit also.
आपने तो reply नहीं किया सर.
No replies.
We are not opposing.
Manoj,
2023 से reply नहीं किया आपने.
Continuation.
We deal that you have no objection.
बाद में सर ये एक्चुअली डेथ हो गई थी फिर एलार्स बाद में आए हैं.
अच्छा.
We'll also file Manoj.
Reply.
Reply to the
Death कब हुई?
My lord, that application has been allowed by my lord and we have complied.
Death कब हुई?
My lord, it was during the application. With
सर्टिफिकेट वगैरह कुछ नहीं लगा, डेट भी नहीं लिखी. ऐसा तो नहीं पिटीशन के समय ही होगी. कब हुई है डेथ? कहीं कोई एप्लीकेशन नहीं है, कोई डेथ सर्टिफिकेट नहीं है.
will, my lord, we have filed the application, but my lord, that is true, my lord, that death certificate is not there.
तो कैसे मान ले भाई कि डेथ हुई है?
हम लेके इनसे we'll file it.
अरे डेथ कब हुई है? पिटीशन के समय हो गई क्या? ऑर्डर अगेंस्ट डेथ पर्सन तो नहीं हो गया?
हाँ.
फेवर ऑफ डेथ पर्सन. नोबडी हैज चेक्ड इट.
वो डेट नहीं है.
हाँ. एलआर को भी नहीं पता है.
Alas, the council is there for
the
their.
death certificate of Rajendra Kumar Patel, red petitioner, we brought on record
Man.
in order to verify whether he died during pendency of petition or during pendency of writ appeal.
Grateful.
आप लोग चला रहे हैं तो आपको भी नहीं पता, आपको भी नहीं पता, आपको भी नहीं पता इंटर नहीं.
जी सर, हम 23.1
एलार्स के लिए
कैसे तो रिलेटेड है.
नहीं सर, हमारे
सीलिंग से रिलेटेड इसलिए कनेक्टेड है.
पॉइंट से.
But case dispute से related.
The council for the alerts is also there, madam. We'll get it.
Either party can submit.
Either.
Verify तो हो जाए.
जी.
आपकी क्या है? आपकी स्टेट की है?
हाँ, स्टेट
State.
इसमें भी डिले.
इसमें भी ले
19 से तो यहाँ चल ही रही है, अब डिले क्या है?
उसमें उससे ज्यादा भी डिले भी नहीं
है.
ज्यादा डिले भी. इसका ऑर्डर है, रिव्यू लगा, ये रिव्यू 20/9/19 को खारिज हुई है.
इसका डिले कंडोम करते हैं.
और 19/11 बनाना पिटीशन.
Much.
सर कोई रिप्लाई नहीं.
बट माय अपोजिशन पर
ओरल अपोजिशन. नेक्स्ट.
Malord, in writ appeal 7/34/2020, my application for intervention is pending.
23.1, my application for intervention.
आप इंटरव्यू कौन
We are the intervener in that case because.
और लीगल ईयर
23.1 में. But that is in 23. Legal year was in 23.
अच्छा, you are appearing in 23.1. We'll consider. We'll hear you.
Malord, in 23, my application for intervention is also pending.
How many interviews?
Malord, I was the original owner.
ये 23 में क्या?
मैं 23 में बोल रहा हूँ.
वेट करिए, तो उसका स्टेटस डिसाइड होना है.
Item 24.
24.
Yes. सर इसमें रिस्पोंडेंट नंबर 12 को नोटिस सर्व हो चुके हैं.
I am appearing for respondent number 12.
12.
I am appearing, please.
Reply देना है.
So, my lord, I've just sought instructions, my lord. I've just got instructions to appear, my lord. I'll file my wakalatnama and reply, my lord, in 4 weeks.
Millard, this matter.
Receive the instruction of drawer number 12. To file wakalatnama as well as one reply.
कोई बी कमीशन दे दें सर इसमें, क्योंकि इलीगल माइनिंग का मैटर है सर ये. और दी एडमिनिस्ट्रेशन फेल टू रेस्टेन मिलट द हाइवा एंड पोकलैंड मशीन P9 मेकानली सी लट से.
तो पहली बार अपीयर हो रहे तो टाइम तो देना पड़ेगा.
नहीं, but it is the duty of the administration to restrain Millard. This is the rules is also.
Administration is taking.
They are not discharging their
Narda.
duty. That's why you are here.
Yes.
They are not discharging their duty. That's why you are here.
Lordship, administration is taking constantly action against illegal mining.
Not only this Millard, the also the PESA Act provision is not followed.
ठीक है, we will consider. State का आगे रिप्लाई.
State का आगे.
हाँ.
Reply file. My lord,
within 2 weeks. Sir, 2. This immediately after. Like. Mining का तो नहीं.
Yes, 25. My lord, in this case, my lord, I have filed an application for registration of my project. My lord, on May 2017, RERA Act came into force. Now I filed an application on October after 5 months. Limitation was of 3 months. There was a delay of 2 months in filing application, my lord. They, my lord, they in fact found 3 deficiencies in my project. First was I do not have EWS permission. Second, I do not have a colonizer license. And third, my lord, late fees. Lord, so far as late fees is concerned, Lord, they fined me for 1 lakh rupees. By annexure A3, I paid rupees 1. No, my lord, they have not been filed, my lord. They have not filed. And my lord, rest of the 2 deficiencies has also been rectified, my lord. There are no deficiencies as such. My lord, I filed an application for reconsideration. My lord, in fact, my lord, what I am praying that I have already filed fresh application. My lord may direct them to reconsider within 10-15 days. नहीं, मैंने fresh application file कर दी है, my lord. I have paid 4,27,000 rupees of fees. If my lord may direct them to please consider my fresh application within 15 days.
Yes, any objection?
Lordship, I appear through VC in this matter. Lordship, the requirement to dispose of the application in 15 days is lesser than what the Act permits us. Section 5 of the Act gives us 30 days to decide their application. If he has filed a fresh application, we have no objection. We will reconsider it, Your Lordship. That is no difficulty.
Counsel for the petitioner fairly submit that the petitioner has filed an application fresh for registration and seeking direction to the respondent to consider in accordance with law without being influenced by the earlier rejection orders.
Yes.
Counsel for the respondent submitted the application will be considered in accordance with the RERA Act.
Not any time limit, 30 days.
No time limit has not correct. Within the time limit prescribed under the Act. Right?
Highly grateful, Your Lordship.
Wait, please, madam. Madam, the petitioner was granted a rate contract for supply of general surgicals like needles, florins, and other things. Now, it's a writ appeal, my lord. We challenge the termination order and order of blacklisting before the Honorable Single Judge. And they have rejected it on the ground that my lord's notices were served to us and therefore the blacklisting is proper.
Now, if Lordship sees, my lord, there were no deficiency, we say, in service, whatever, we had given a wrong product to them. And giving a wrong product would not, should not be taken as black. My lord, we were to supply Venflons, my lord, with air vent. We supply Venflons without air vent. And those, my lord, it was, no, when they gave us a notice, no, when they gave us a notice, my lord, we gave a reply that it is by mistake that it has done. We are ready to replace them. And we, my lords, in fact, after the orders of the blacklisting also.
For how much?
I apologize.
3 years.
Even period for 3 years.
3 years.
3 years, my lord. Blacklisting
That's as
for
per the
3 years.
contractual terms.
Now we say that there is no.
So 2 years has already been passed.
2 years have already been passed.
वो
करने पर would not come in way of, my lord.
Once or twice that happened. It has happened more than 38 times, my lords. The show cause notice, I'll just read that, my lords. And the testing was done for the product by 5 laboratories. Retesting was done again, my lords, and all the laboratories report came that it's not of the standard quality, my lords. I'll just point out. All these are the part of the record only, my lords.
The laboratory says that the sample is perfect, but for that spike which was to be added, my lord, that was not there. That is the air vent in the Venflon. The product, if lordship sees the laboratory report, my lord, was perfectly all right.
You are supplier and you don't know the difference.
No, my lords, we admitted that.
What's the rate difference?
Hardly a few paisas, my lord, not more than that. My lord, we had given more than 1 crore samples to them. And out of which, my lord, few samples, we admitted our mistakes, my lord. In our reply also, we stated that it is due to mistake that these items were supplied and we are ready. It would be at the most a case of breach of contract or supply of wrong material, my lord, which should not come.
What else is required?
No, for blacklisting, my lord, breach of contract should not be a ground for black.
You have not supplied a product for which the contract was awarded.
My lord,
you became relevant by putting a rate of a product. Desired by then and supplied the product.
My lords, we supplied, my lord, we were to supply 53 lakhs, my lord. It was a rate contract. We supplied more than 1 crore of Venflons to them.
You are admitting your.
We stated that it was a bona fide mistake, my lord, which went. If lordship could just see, my friend has raised this point that the samples were not tested in the laboratory as correct sample. The laboratory reports, in fact, says that the sample is correct, but for that the spike which was to be attached to the sample was not there.
Single only blacklisting. Only blacklisting.
No, termination.
Or of termination.
Blacklisting as well as termination. My lords, that was 2 crores 72 lakh 60,000.
Rate contract.
My lords would find it at annexure P2, my lords, page number 53.
Probably, sir, because it was rate contract, तो उसमें contract value नहीं थी contract. This is what I presuppose.
आपको नहीं पता था contract value क्या है? Why you did not disclose?
I just take my lord's attention to P7 minus page 67. ये देखो इसमें 9/24.
So P9 के कारण probably it went before the honorable single.
9 लाख की रिकवरी
जी सर।
हो गया 9 लाख रिकवरी और 3 साल का ब्लैक लिस्ट।
सर व्हाट टाइम
आपका सैंपल फेल हो गया।
नहीं सर, सैंपल वही सर।
P7 is relevant.
सर P7
Page
देख लें।
67 months.
We also
That
rely
was
on
the
those samples.
show cause notice we gave when we found that these were not as per the standards. Prior to that also one more show cause was given because they were not supplying the goods on time. So they tried to withdraw the tender. We gave them a show cause notice after that also because we specifically stated that your withdrawal of the tender is on 19/12/2024, whereas much before that you stopped supplying many of the purchase orders.
My lord, if lordship could just see P7, my lord. Is there sample testing, my lord? From point number 1, the sample reports, my lord, which would be on page 70, my lord, of the writ petition. P7. P7.
P7 is the show cause.
Show cause notice, उसके पीछे test reports हैं सर।
The first.
There is an admission by you.
We bona fidely admitted, my lord. These samples, if lordship could see, my friend is relying on those test reports, my lord.
You are admitting it.
What I most respectfully submit, my lord, we say that it's a bona fide mistake.
Bona fide कैसे हो?
नहीं सर, वो इतने सैंपल्स जाते हैं कि वो एक गलत बैच चला गया जिसमें वेंफ्लॉन में एयर वेंट नहीं। 5 का नोटिस
नहीं 38 बैचेस सर, पेज नंबर 68 फर्स्ट पैराग्राफ।
My lords, we immediately sent the reply.
So that is
absolutely different.
And
38 बैचेस।
गलत दवाई सप्लाई कर देंगे तो what will happen?
नहीं सर, ये गलत दवाई का नहीं है, गलत
ड्यूरिंग द कोविड पीरियड में
इसके लिए सप्लाई होना चाहिए तो।
सर हमारा एक निवेदन है, we have already suffered 2 years. That is more than enough for my lords for a wrong act committed, my lord, that too bona fide.
उसके लिए क्या कहना?
My lords, may just see one aspect. P7, page number 67, my lords. Page number 68 is important. Why I say it was not bona fide is first paragraph only. उक्त सामग्री के आपके द्वारा प्रदायित 38 बैचेस को पूर्व में
You have already forfeited 9 lakh. Recovered 9 lakh.
That is only the batch value. That's only the batch value. The tender was for 200.
Termination of contract.
And termination that we had to do because
the loss of profit is there. So two punishment has already.
That all these are as per the tender terms. The tender terms is
that we are not discussing that. The only period 3 years to 2 years. कितने batch भेजना था?
38 batches गलत supply किए। 38.
How many batches?
Sir, out of 1 crore
fail हो चुके हैं।
वो भी out of 1 crore product we supply. We have supplied more than. Sir, हमारा जो
one batch may contain many batches.
Sir, total हमारा जो rate contract था वो 53,79,650 for this thing. We had supplied more than 1 crore of quantity without any complaints.
How many were found defective?
I apologize.
How many were found?
Only 38 they say, my lord.
38 products is 38 batches. One batch may contain 5 lakh products also.
So all products were fine. Only those air vents were not there in Venflon. We also supplied needles. There were no complaints with regard to needles. We also supplied other articles, man.
The 38 batches cannot be quantified because there is no.
But after yearly, in order to win a new benefit or deliberately.
Yes, my lords, that is deliberate because.
But they have replaced it.
No, they have not replaced.
No,
we did not allow them to replace because.
Later is that
we immediately said, my lord, whatever batches are replaced, my lord.
They were ready, my lords.
Before any litigation,
my lord, may just see first paragraph only, page 68, P7, part of P7. I was just reading that. उक्त सामग्री के आपके द्वारा प्रदायित 38 बैचों को पूर्व में मध्य प्रदेश पब्लिक हेल्थ तो से अनुबंधित NABL लेबोरेटरी
हो सकता है एक कुछ बैच गलत चलेगा।
सर एक बैच नहीं, या तो फिर आई विल हैव टू सीक इंस्ट्रक्शन 38 बैचेस में कितने प्रोडक्ट है? एक बैच में 5 लाख प्रोडक्ट भी हो सकते हैं
सर हमने 2 साल सप्लाई किया कंटीन्यूअसली।
The work orders flows from various authorities across the state of MP. ये जो 5 बैचेस फेल हुए थे सर, स्पेसिफिकली 38 में से 5 वो शाजापुर, दतिया, रतलाम, अशोकनगर और जबलपुर के फेल हुए थे। There may be many other batches, 38 to which came to our knowledge, my lords. And those 38 batches may contain 50, 20, 25 lakhs of product out of that 1 crore which my learned senior is saying. So because that's not their feeding anywhere.
क्या डिफरेंस है दोनों प्रोडक्ट में इंट्रावीनस सेट एयरवे और विदाउट एयरवे?
Sir, if lordship knows, my lord, the air vent, the Venflon which goes, my lord, then there is a spike on it. एक में स्पाइक थी, एक में नहीं थे। बाकी जो इनकी लेबोरेटरी की भी रिपोर्ट है कि the product was perfect. only the last line they write, my lord, after complete testing, that only the product misses the airbag. It does not make the product bad at all. It does not make it harmful for this thing.
But these are two completely different products, completely different. And this is during the peak COVID period, second wave, my lords, that they committed this mistake. Yeah, 2022 is the rate contract, my lords.
So 22. You gave me the first letter in 23-20.
P5 may be seen. They stopped
that was
delivering
24,
the
there
product
was no COVID.
from 23 only, my lords. We gave them a specific notice, page 63, P5.
So they were also working during COVID.
जी सर उससे आपसे रेट्स भी ज्यादा थे.
Some leverage will be given to them also. As the Supreme Court has given the benefit of limitation to all.
जी.
So they also working during COVID period and supplying products to meet up that.
But my lords, my most humble submission, my lords, is a wrong product to a patient who may be unconscious.
Bona fide mistake, not deliberately they are supplied.
My lords, these products may run into.
Sir, it was to continue, my lord. The contract was for 1 year initially, but they say that I was duty bound to supply whenever as long as they keep on demanding. We also wrote them, my lords, that we may be relieved of this contract.
Page 53, my lords. 14th March 2024 was the last date, my lords.
We are not questioning entire thing, we are reducing the period of black question. 3 years का कोई fixed criteria है?
नहीं, हमारे tender में है sir. No, contract says 3 years, my lords. That is why we have blacklisted them for 3 years. That's a particular clause. The tender clause only says 3 years. But उसी के एवज में तो हमने blacklist किया. That contract says 3 years, my lords. My lords, में just see. जो ये page number 68, my lords, part of P7 show cause में दिया हमने. The contractual term says 3 years. So that is why we
terminate कर दे.
Blacklisting, termination, and batch value was recovered because those batches was wrong, so we did not use them. So they always had the right to pick up those old batches.
The order of blacklisting should not come in way for future. But it should not come in way for other applications.
So my only request is, my lords, my arguments to the extent that
Oh sir, वो Blue Dreams वाला भी लाया और Techno Prints भी लाया, वो we have uploaded.
Techno Prints, my lords, paragraph 38 goes against them. My only humble request is my submission to the extent that 38 batches are found to be not of standard quality, that may be recorded. It's there in the show cause also, 38 batches, which may contain lakhs of products. Oblige, my lords.
This is got to be argued finally.
Your Lordship, I'm appearing through VC on behalf of the respondent.
You can see that you are appearing through VC. You need not to disclose that or inform.
Your Lordship, the senior arguing counsel is not available at the moment due to certain family emergency, but he is willing to be physically present before the honorable bench and argue the matter. So I request you kindly appoint the date in the month of July.
You're telling the award?
It's not, conciliation proceeding to conciliation notices were issued. But we did not appear because then without issuing.
Are you aware about the rate of interest?
Yeah, but my case is
very consuming time.
My case is squarely covered by Jharkhand Urja Vikas Nigam's case, Marot, that the award is not an award itself. I'll just demonstrate. Let them appear in July, Marot, I have no issue.
Is that counsel you are not in urgency? Counsel appearing for the respondent number 1. We are appealing for 1.
Yes, Your Lordship. for responding.
I have to continue, madam.
Your Lordship, kindly appoint a fixed date for the council to be physically present. Before the
We have reached prior to that.
Oh. My friend has to be.
If you apply, not. This is a matter where it is coming after notice.
What is the urgency?
I don't have urgency.
No,
but-
they may not have, not I
No, no,
have.
can I?
Interim relief is operating against me for almost 13 months by now. 14 months. No, I'm sorry, 13 months. Ex parte order.
Which part?
My Lord, I am appearing for respondent number 3. The money has gone from my pocket to his pocket. And that is where the state has intervened. State means agency of the state, Road Transport Corporation, with a notification holding that they have collected the toll much in excess and in misinterpretation of earlier GR. I'm not arguing on merits. It's my friend's privilege to begin, but I'm only answering the query of the court. And that's why, my lord, my 11 crores and 84 lakhs of rupees have been, my lord, stuck up. And I would request, it's a fixed matter, my lord, if your lordships can have it at 2:30. Subject.
There is a mention also.
My lord,
This will
sorry,
be taken in.
let my learned friend finish.
There is a mention in the causes also that this matter will be taken at 2:30. On the last dates, my lord, the honorable advocate general.
We have no plan to work in.
I'm only.
We are not saying that your lordship should take up. We are only requesting and praying before your lordships may kindly take up.
If I may, Lord.
That no council can bind the court. Council has a right to request.
Lord, it's often said at this particular hour to mention anything is.
Who knows better than my friend?
How much time will vote will take?
But I don't wish to argue for.
How much time?
I'll take about 45 minutes to an hour.
45 minutes.
To an hour.
45 minutes.
No, me 10 minutes. Outer limit 10 minutes.
231 matter is going on. Hearing is going on before DB2 1. कई बजे उसको फिर से रखा है सर आगे आगे उसमें और बहस होनी है सर मैं उसी में हेल्ड अप था 2:30 बजे हो रही है
I may only indicate, my lord, this was not an ex parte interim order. Then there was a modification also. But I have no difficulty. If my lords so choose, we are ready to.
Well, can it be done this way, subject to your lordship?
Taken up at 2:30, I'll join later, sir. With your
That's what
lordship sign permission after 5-10 minutes.
In fact, my learned friend has to begin. Thereafter, learned advocate general, and my role would come only after learned advocate general, my lord, is through with his arguments. But I can assure my lords, I don't wish to argue for more than 10 minutes. Because more or less, learned advocate general would cover.
Lord, the only thing is, I am being wrapped and I am being told I have corrected excess toll when I did so at the say-so of the state, which is respond number 2. They issued a fee notification. I went along with that. Lord, you know, Lordship knows when you pass a toll gate, Lord, there is classification of vehicles and the toll is collected as per the classification of vehicles. Now, Lord, the central government of India, my Lord, through NHAI and the Highway Authority introduced a fast tag scheme, you would have seen. Now, my Lord, depending on that, I did whatever had to be done. And suddenly the state gets
The short question, my friend is right, the short question is that field is occupied by GR, issued in the name of His Excellency the Governor of Madhya Pradesh. And one officer of the state, misreading it, issues another later-like thing, which will have a cascading effect of overriding the GR. That's the only point.
As far as
I am not a transporter.
Yes, yes.
Yes, everything is paid.
And now,
recovered from your passenger. Will not.
No, I cannot. This is not a case. I'm sorry. This is not a case of undue enrichment. Had it been a case of no, we don't recover, my lord, toll from the passenger. It's paid from your pocket. Yes. We don't.
My lords, may I make a request for item 32, my lords? It may be kept for Monday. It is a demolition matter, my lords.
किसी और का अर्जेंट है क्या? पहले ले लेते हैं। 2 मिनट बताइए क्या? अभी बताइए।
The argue counsel is not in the court.
नहीं, अर्जेंट हो तो अभी बहस करेंगे।
My lords.
बोलिए।
My lords, the counsel for the applicant is.
You are from?
I am for the respondent, my lords. I am for the municipal council. I am for the municipal council, my lords.
Please sit down. Let the petitioner come and argue. Don't make a request for other. Yes, 28.
Yes, my lord, with your lordship's permission, my lord. May I just say briefly in the opening what the matter is about before your lordships are taken through the papers?
Try to maintain the time. Otherwise.
My lord, I'll try my level best, which is why I'm attempting to give a overview of the matter first before we take my lords through the papers. My lord. The short point involved here is this, which I said before lunch, that the impugned order, which is passed by respondent number 2, my lord, which is MPRDC, is suggestive of the fact, and according to us, wrongly, that we have collected excess toll, my lord.
Yes.
And that because we have collected excess toll, we are also liable to pay damages. Now, how did this event happen and why did this impugned order get passed? It got passed based on a representation by respondent number 3, my lord, who according to us is an interloper, because the agreement is between me, that is the petitioner, and respondent number 2, which is the MPRDC. My lord. Now, as I was telling my lord again before lunch, earlier we used to collect toll manually. You pass the gate, the person would look at the vehicle, see what kind of vehicle it is, and accordingly, my lord, according to the classification, collect the toll. When I entered into the concession agreement, because what was the concession agreement, my lord? I had to build a 4-way Bhopal-Devas tollway, my lord, and I was allowed to collect toll for a period of 25 years, which ends in 2033 or so, my lord. Now, my concession agreement was executed on 30th June 2007.
Yes.
It has a couple of clauses which are very relevant because the impugned order is passed in under one of such clauses, which according to me does not cover this situation. Now, when this concession agreement was signed, my lord, there was a notification already classifying vehicles according to, my lord, if it was a bus, empty or loaded, truck, multi-axle truck, etc. They had different toll rates. That was part of our concession agreement. 2013, my lord, the government of India, through MORTH, which is the Ministry for Transport and Highways, NHI and IHMCL, which is the Indian Highway Management Company Limited, formulated what is known as a fast tag scheme. Now, under the fast tag scheme, my lord,
yes,
the classification of vehicles was changed. This happened in 2018, and there were two defining parameters based on which toll would be collected, i.e., the number of axles that a vehicle had and the gross weight of the vehicle. Now, this is important. I'll not just keep that in mind. When the scheme changed, the weight of sorry,
who framed that scheme?
My lord, that scheme was framed by the government of India, NHAI, and the Highway Authority. My lord.
The statutory scheme or?
Well, my lord, this is a scheme which there was in this case, my lord, as far as
non-statutory, but effective penning.
My lord, I'm, I think, very capable of answering queries that fell, my lord.
I'm sorry.
Please take your
My sincere apologies.
Yes.
Yes.
Thank you. Lord, this was pursuant to an MOU executed between respondent number 2 and IHMCL, which is the Indian Highway Management Company Limited, which is an adjunct of NHAI. Nobody your lordship knows. NHAI is handling all this, maybe a subsidiary also. Now, that MOU, which is of 25th February 2022 said, if you want to avail of the fast tag scheme, you have to adhere to the classification that we have given, because there are only 7 classifications. And there were 20, what they call, my lord, 20 mapping points, and they were, my lord, iterated to 7. As I said just now, my lord, the classification for the fast tag scheme was only on 2 basis of 2 parameters. 1, what is the gross weight of the vehicle? 2, how many axles it has. It was not whether you are in that sense, an empty bus or a loaded bus, or as it happened earlier, my lord, whether you are a multi-axle truck or vehicle. Now, under the concession agreement, and which is also important to bear in mind, is, my lord, my toll rate was always fixed by respondent number 2. I had no leeway, whether it was under the old regime or under the new regime. So when they issued a notification, fee notification, as I'll show, I had to, my lord, collect toll at that rate. Under the fast tag scheme, to which respondent number 2 aligned and said, yes, we also want a fast tag scheme, and your lordship knows why. Because there used to be a lot of leakage of toll. The man sitting at the toll would sometimes look the other way, and, my lord, a vehicle which should have paid a greater amount as toll was allowed to go, whereas the other one wasn't allowed to go, etc., etc. They wanted A, no leakage, and B, that it should be seamless so that people can just zip through, as it happens, my lord, now in most modern cities. One travels abroad, it happens there as well. So respondent number 2, this is Roya looking at something.
Yes,
your lordships are looking at something, I thought. So, respondent number 2, my lord, as I said, entered into a MOU with NHAI and IHMCL, which said, we will allow you to align yourself with the fast tag scheme, and you will follow the classifications that we have given. Respondent number 2 said, well, yes, we will adhere to that. And there were notifications of 2018, which was earlier, and then, my lord, the MOU of 25th February 2020, and then the scheme kicked in. Now, from 21 to 24, my lord, this went on. I collected toll, and this is electronic collection of toll. And may I just say how it operates, my lord? It's very,
You know that
you lordship knows.
frequent traveler.
And, my lord, another thing that your lordship may also bear in mind is, when I collect toll, there is a certain amount of monetary fee which goes to respondent number 2. So if I collect, say, my lord, 100 rupees, in the first 10 years, 1% went to respondent number 2 as monetary fee. Then between 11th and 15th year, it got raised to 2%. And from the 16th year onwards, it got raised to 3%. So the question is this. If I am bound by your fee notification, which respondent number 2 issues, whether under the old regime or under the new regime, am I collecting in excess? That's one, my lord. 2, if I'm not collecting in excess because you have issued the fee notification and I cannot, my lord, in a sense, sidestep it, then am I in breach and can you impose damages? Because the impugned order, you would have looked, and I will just go through that, says you've collected in excess and therefore you pay damages. The third important question is, what happens where the state itself is collecting? It doesn't have a concessionaire. I'm a concessionaire here. I'm allowed to collect. Where the state is collecting, is it saying that it collected in excess when the fast tax scheme was there? Lord, interestingly, the state doesn't answer this. In fact, I am told, this is on instructions, and I, my lord, would sort of implore your lordships to issue a direction to the state. What are you doing vis-a-vis highways which you are manning, which are under the fast tax scheme? Are you saying that you are collecting in excess? It's like someone shooting himself in the foot. As far as I am concerned, my lord, they are saying I am collecting in excess. Correct? And I have no leeway. My lord, it's like I'm between a hard rock and a deep sea. If I did not follow their notification, I would have been in breach of the concessionaire agreement. It would have been terminated. If I follow, they now, on his representation, my reference client's representation, respondent number 3, said you collected in excess. Whereas, my lord, where they are concerned, vis-a-vis their states, there is complete radio silence. Now, in that light, my lord, we see a couple of documents, and I'll take my lords through that. First is the, my lord, the concession agreement. My lord,
15.
my lord, your lordships have a convenience file. I put all the documents that I wish to rely upon in a convenience file. It's my lord. It's the last document in my lord's ERP.
Concession agreement is Riksha P1.
My lord, your lordships are going to the annexures. I have a convenience file of the documents. That's at the end, my lord.
Can you please give us?
This file that your lordships have, electronic file, my lord, at the end it says convenience file, the last thing.
List of date.
List of things,
17.
and then the convenience compilation. My lord, have that?
Yes.
Yes, document 1. Correct, my lord?
Yes.
Now please see at page 2 of this convenience file. Justice Mittal has that?
Yes.
My lord, at the top of the page it says concession agreement dated 30th June 2007. Now please see clause 5, which is at page 5. Applicable law means all laws promulgated or brought into force and effect by Government of India, including rules, regulations, and notifications. You know, this is important because fee notifications are what are determining the issue in this matter. I'm not reading the rest, that's not necessary. Please go to, my lord, straight away to 45 at page 7. The clause 45 at page 7. My lord.
Digital paper.
Fee, my lord.
45.
Yes, my lord. It defines fee at page 7. Page number is at the top of the page.
Page number. 45. Fee.
Fee, my lord, means the charge levied on and payable for a vehicle using the project highway, which is the Devas Bhopal highway in this case. In accordance with, please underline this, fee notification and this agreement. Please underline fee notification. Now, my lord, how is fee notification defined? Please see page 40, clause 46.
Yes.
Fee notification means notification dated 30th December 2006. Now, this was part of the concession agreement. There was a classification. I'll take my lords through that. Issued by Government of Madhya Pradesh, exercise of powers conferred by Section 2 of the Indian Tolls Act, etc., in respect of levy and collection of fees, and a copy of which is at Schedule C, and includes, my lord, this is important, any such, does my lord have that? Any such subsequent notifications issued from time to time to give effect to the provisions of this agreement. So there was a notification of 30th December 2006, which was, in a sense, incorporated in the concession agreement of 2007, but the concession agreement itself said that they could issue fee notifications thereafter also. Now, Lord, please come to page 9, clause 6.9.3, under the heading display of fee rates.
Yes.
My lord, is that? Now, this is the clause based on which the impugned order has been passed. And please read this with me carefully. The concessioner, that is the writ petitioner before my lords, shall not revise, display, or collect any amounts in excess of, please underline that, Lord, of the rates of fee payable under the fee notification. So it would be in excess only if I charge or collect rates in excess of the fee notification. My lord, has that, Lord?
Yes.
So excess has to be understood in that sense. In the event any excess amounts are collected by or on behalf of the concessioner, it shall, upon receiving a notice to this effect from MPRDC, which is respondent number 2, refund such excess amount to MPRDC along with damages equal to 25% thereof.
They are invoking this clause.
Yes. Now, Lord, then they say if there are repeated instances, they can also terminate, as this will become major breach. Lord, just pause here for a moment. 2 points arise, according to us, or here, two issues rather. One, can I be in excess? Can I be in excess of rates of fee which are collected as per the fee notification? If I am collecting as per the fee notification, surely they can't be in excess. And what does that mean? That's one. The second is, you are also going on to impose damages. Of course, if the fee notification says 1 rupee per kilometer for a particular vehicle and I collect 2 rupees, you will say 1 rupee is in excess and we are also going to charge multi with damages. But if I am collecting at 1 rupee, you can't say I have collected in excess and evoke this clause and then say damages because I'm not in breach according to it. Right now? Now please see clause 6.10. Concession fee and project monitoring fee. This goes to respondent number 2, which has passed the impugned order and is beneficiary of the collection that I made, right or wrong. Please see 6.10.3, the third subclause. 6.10.3.
Yes.
The concessioner shall pay to MPRDC the end of the concession period or the termination of this agreement, whichever is earlier, an amount equivalent to, it's covered by those stamps, 1% of the annual toll collected as project monitoring fee for the first 10 years. What I just said. So from 2007, for the first 10 years, it is at 1% to be counted from the commencement date, and thereafter the amount will increase to 2% from the 11th to the 15th year, and 3% from the 16th year. I believe we are in the 16th year now. So 3%. So what happens is, whatever I collect, a portion goes to them. They say, I have collected an excess. There is nothing about the monitoring fee. Both can't be right. Right, Vinod? Now, please come to page 11. Lord, these are obligations of the concessionaire, which would be the writ petition. And 7.11, Q, levy, PCQ, this is the obligation of the concessionaire. Levy and collect fee for the use of the project highway at the rates set forth in the fee notification in accordance with the agreement, etc. Now, I had no leeway. The point why I'm reading this clause is, if your fee notification referred to, say, 1 rupee per kilometer for a particular vehicle, I couldn't have charged anything less. Similarly, D, on the very same page, 12, comply with all applicable permits, applicable laws and performance of the concessionaire agreement. Lord, that's agreement would be the concessionaire agreement. But please see at page 13, the next page, 16.1, the concessionaire shall operate and maintain the project highway by itself or through O&M contractors, and if required, modify, repair, or otherwise make improvements to the project highway, comply with specifications and standards and other requirements set forth in this agreement, good industry practice, applicable laws, applicable permits, etc., etc. Please come to 16.1.2.
Yes.
Sorry, 16.1.2. It says, one of my obligations here is, 16.1.2 at page 13, charging, collecting, and retaining the fee in accordance with this agreement. So, how do I charge? As per the fee notification. What do I return? Whatever is provided in the fee notification. I am supposed to give respondent number 2 monitoring fee at the rate given in the clause that I just read.
The formula and mechanism provided under that.
Yes.
Under agreement.
Your Lordship, sir. Lord, I can't say it can't be put higher than that, but specific clauses had to be pointed out for the reason, my Lord, that your Lordship needs to appreciate our point of view, which is this. When you point a finger at me and say you've collected excess under the clause that I just read, 6.9.3, it has to be as per the words and the terms, and the plain terms are in excess of the notification. If I have collected over and above the notifications, surely you can point a finger at me. and then ask me for damages. If I have not, then it is completely without jurisdiction, plainly against the language of the concession agreement. Now, my lord,
Professor, you are challenging the notice or demand made by respondent number 2.
Yes.
With whom you have an agreement. That agreement contains arbitration clause.
No.
Why you are not invoking that?
Yes, I'll tell my lords why. That's a very important, significant question.
Yes.
Arbitration clause involves disputes only between the parties what to the arbitration.
Yes.
Large.
You are telling the notice issued by number 2.
Right. No, I am challenging, Lord, that's why I would want my lords to allow me to complete the narration of facts. After 2018, what happened is important. After 2018, when the government of India said, go to this is not in the fast track scheme era. This is 2007. After 2013, my lord, the country moved to fast track scheme. 18, there is a notification. The government comes out with a notification which does not classify vehicles in the manner that they were classified earlier. Which is why, my lord, I started by saying there are two parameters that were fixed after 2018. I'm sorry. So after 2013 and 18, when the first notification came under the first fast track scheme, which was applicable all over India for national highways, the state of Madhya Pradesh said, please apply it for the state highways also. Ours is a state highway. Therefore, my lord, there are other entities which have come into the picture. And interestingly, which is why I said, my lord, the issuer bank, the bank, which is the vehicle owner's bank, which issues the fast track, the acquirer bank, which collects on my behalf. In fact, he went to the issuer bank. I'll show that below. He had in fact applied as per the 2018 notification. That is important. And he got his fast tag on that basis. And the parameters were, I'm repeating myself, Lord, at the cost of repetition. The parameters were 1, weight, 2nd, number of axles, not whether you're a bus, truck, etc., etc. Now, please come to, and I'll come back to this when your lordship sees these 3 notifications.
So you agreed to adopt this fast track mechanism for collecting of that. So you are not challenging that part.
MPRDs, yes.
Despite this concessional agreement between you accepted, it was mandatory, I think, for
everyone
to adopt.
We were under directions. Now,
this dispute arose during currency of that agreement.
The point is this. What is the classification? Who determines the classification? If you have said the classification will be determined according to the fast tag scheme, and that scheme says classification is XYZ, then how does the impugned order stand? One, how do I get the acquirer bank and the issuer bank into the fray, or NHI or MPC, IH, MPCL into the fray? They are not party to it. They will not be bound by it. So the state has to decide. And please see, this is very strange, as I said. The state, where it is manning on its own, in fact, it should be asked by my lords to file an affidavit. Is it going to disgorge all that it has collected under the fast scheme, where it was collecting? Lord, it's very easy to tell the concessioner, please pay him up. It's not even said pay him up, pay me. 2, to find me in breach of something that they told me to do and impose damages of 25%. So therefore, it is important if my lords look at the notifications, and then my lord, your lordship may.
Right to collect toll lies with the state government.
Sorry, Mina?
Right to collect a toll within the jurisdiction of state government.
Yes.
No person can collect it. You have been given that right to collect a toll to recover the investment which you made.
BOT, yeah, your lordship knows, Lord, I've been given 25 years. There is nothing paid to me. My only consideration is collection of toll. Right to collect.
One issue came up before the law, tax matter.
Yes, madam.
The toll that is the money which you invested and recovering.
Yes.
And you are doing discharging the duties of the state government under authorization to collect the toll.
You're right, Lord.
You came before me.
Yes. So whose income is it? I think it is my income because I pay tax on it. Because there is no other
collection of toll is not your right. That is given by the state to you to recover the amount which you invested. Instead of paying that amount in advance to you for construction of a road, government gave you a right to recover that amount by way of toll.
Yeah,
and the moment you will recover, and
it will be transferred back to the state. Your lordships are absolutely right. That's
the scheme of
the model. Yes, yes. But private partnership, all these are various models.
According to step into the state government, and you are doing the collection of under the authority of the state government.
Correct.
So state can't dispute with you.
Correct. And therefore, my lord, insofar as this highway is concerned, yes, I'm doing. I'm just shy.
If you have collected access, means the state has collected access.
Yes, and what this, yes, that's my respectful submission. And the state, very interestingly, my lord, takes monitoring fee. My lord, I showed that clause. 1%, 2%, 3%. In the impugned order, there is radio silence on that. Nothing. And what happens when the state has not appointed a concessioner? It is directly correct. Because not it's actually a dispute in REM. It doesn't involve only respondent number 3. He's got some buses, my lord. There are other also bus carriers.
The major is.
Yes. My lord, I don't want to say this.
One car owner or one taxi owner will not come to you and say that please.
No, there are other. So there are other bus owners also. So this is a cascade. Now, my lord, if you ask the state to file an affidavit on 2 things: 1, what are you doing where you are collecting? 2, are you refunding that? Lord, I am told, and this is something the state knows because they have everything deep in their files, Lord. And we all know, not only the court can ask them for those file an affidavit. They are asking them, please refund. They are saying, no, we will not refund. Now the matter is in court. It's very convenient. You passed this order where you said refund. And most crucial question is respondent number 3, which according to me, in a sense, is a meddlesome interloper in a contract between me and the state. My lord, your lordship said, and he kept quiet. He went to his own banker saying, although I have got a fast tag, and that's the admission in the counter affidavit, under the classification given under the scheme, please reclassify. His bank said, no, nothing doing. This classification is right. Because you have buses with 3 axles and your gross weight of the vehicle is between 16.20 tons and 25,000 tons. Therefore, this is the correct classification. Now, under that scheme, there are also buses with 2 axles, correct? And lesser weight. So there is a different classification. What he is confused is, I am a bus, which was under the earlier regime. I am an empty loaded bus. I can only be a bus, and therefore I have to be charged according to that. The state has done him a great favor by passing this impugned order. What is it, my lord, in a sense, what is it so unique about it? Whereas all other bus carriers, where the state is also collecting, is not being met with the same.
Is there any difference between the rate fixed in this for FASTag and the rate fixed in this fee notification?
Yes.
Large difference.
Yeah, they will be, because if you go by access.
Fee notification is issued by the state government.
Yes, under the Tolls Act, they have power under the Tolls Act.
And that FASTag fee schedule or notification fixed by the central
So, my
government.
lord, it happens like this. If your lordship would see the next page, page 17, please see page 17. 17. 17. Of the convenience where we were, my lord. Convenience compilation. Does my lord have that? 30th December?
Yes, 17.
2006. Now, this was the regime operating when the concession agreement was executed.
Only 5 categories are there.
Only 5 categories.
LCV, empty and loaded bus.
Now,
same for loaded truck.
Oza, if you don't mind, I'll
clarification.
Oza, please don't break my train of thought. It's not fair. This only happens here.
Have patience to get chance. Yes.
Yes. Now, please see, my lord. Page, the 5 categories, my lord, noted.
Yes.
Now, we are concerned with serial number 3 and 5. I'll tell my lords why 5. It says empty and loaded buses. The rate, as my lord said, is much lesser than multi-axle truck. Correct? So, at that time.
Flat rate. Multi-axle truck.
Correct?
Flat rate 3.9.
3.93. My lord, it's per kilometer. If your lordship would see at the heading.
But not bus.
Not bus. Now, so we were charging him at 1.64 because this was the fee notification when we entered into concession agreement. Now, please go to 2000. I'll show my lord. 2009. Just read the 2009 notification. Page 40. Page 40. Does my lord have page 40 now?
40.
Yeah, I'm sorry, I'd have to take you back again, but please come to page 14.
14.
40. Because after 2006,
Yes.
there was a slight change in one category, that multi-axle truck became, does my lord have that, 26 March 2009, page 40.
Yes.
And this is also issued by respondent number 2, the state instrumentality. Concession agreement. Now, page 41. Please note, they change it to multi-axle vehicle. Correct, Manoj? Now, they change it to multi-axle vehicle. They still retain bus. They don't say how many bus has to be identified by number of axles. So,
Bus is a separate category.
correct. So, correct. You had some multi-axle vehicles. We continued. We said, fine, you are still a bus, because it doesn't say that the bus is now to be identified based on number of axles. Now go back 2018 when the regime changed. My lord, just oblige me by going back, my lord, to page 20.
Yes.
My lord, at the right hand side, top of the page, it says 50 June 2018. I'll read this slowly. Now, the subject is, and this is issued by the Government of India, MORTS, Ministry of Road Transport Highways. Not at the top, that's given just at the listen.
Yes.
It says implementation of electronic toll collection program in India. FASTag issuance vehicle classification document. Now, this is when the scheme, first time the notification comes. Reference letter dated this addressed by MORTS, Government of India, to NHAI. It says proposal, that is the vehicle classification, please underline this. Classification document was perused in this ministry. The following comments are made in this regard. NPCI, this is the national payment, this is the platform where all these electronic, when we transfer money, that's the platform which helps in settlement of payer and pay. And IHMCL, this is the highway authority, shall ensure that mapper class / tag class assigned to each categories of vehicles shall adhere to notification of 1810-1996 scrupulously. GVW, this is gross vehicle weight, indicated in the registration certificate, and physical verification of number of axles shall be the sole criteria for assigning the tags to respective tag class vehicles. So, two things, GVW and number of vehicles, axles will be the sole criteria. My lord, has that?
Yes.
I'm skipping the rest. Please go to 5. User fee collection from 3-axle vehicles. Now, please see this, not the change. Bus or truck. They're emphasizing on number of axles. Doesn't matter whether you are truck or bus. Shall be done under, this is a typo, should be 3-axle commercial vehicle. Number 5, my lords, have 5. Class of vehicles in NHV rules 2008 with GVW exceeding, and this is the weight, 16.20 tons, exceeding more than and less than 25 tons. So, 2 criteria, my lord. If you are a bus or a truck and you have 3 axles, my lord, has that? And your weight exceeds 16.2 but is less than 25 tons, then you will be treated as a 3-axle commercial vehicle. That's the classification.
Yes.
Now, at the end, my lord, of course, para 2, it says, in view of the above, ministry may have no objection to the vehicle classification of the last paragraph of this document, page 21.
Yes.
Document for circulation, tag issuing banks, which means, my lord, the owner's bank as well as the collector's bank, FASTag subject to adhering to notification number 1810-96. Now, please see the classification document, which starts at page 22.
No, but MPRDC is issuing a letter revising the rate as per the schedule fixed in their original agreement, but they are not saying as per classification done by this fast track.
Yes, yes. My lord, I'll show my lords.
Why you are, they come to their letter at page 57. Still there is a loaded and empty bus, 194,
Lord, that's-
loaded and empty truck, 233, multi-axle vehicle, 454. They are not changing their.
No, no, my lord, the point is, as I said, if there is a fast tag scheme, which is applicable to you, which you have accepted by signing an MOU.
Who told you to go with the fast tag scheme?
No, no, the state has got, my lord, I have no leeway.
Here the NPRDC is fixing a rate for toll tax.
My lord, we see.
Page come to page 56.
My lord, I'll come to that. Can I just, I'll come to that. My lord,
Where is the letter by NPRDC? You go by this rate to collect the toll.
My lord, under which category? That's
Category they have classified in their letter.
My lord, they can't.
323.
My lord, we see.
Heading are same.
No, my lord, would your lordship see? That's the catch. My lord, first I showed my lords, what did they do in 2009, lord? They changed it from multi-axle truck, which was in 2006, to multi-axle vehicle. Correct, my lord? Then, when 2018 notification came, it's important to, my lord, at first blush, my lord, your lordship is saying what the state is doing is completely right. It is completely wrong. That's our respectful submission. And please read with me, my lord, the document, the classification document. Lord, you cannot get into a fast tag scheme unless you adhere to their classification, my lord.
No.
My lord, you can't.
Your agreement is prior to this.
No, no, my lord, but you are in a fast tag scheme where there is an issuer bank, there is an acquirer bank.
But NPRDC is not insisting for implementation. They have fixed their own rate.
No, my lord, the point is.
And classification is exactly same.
My lord, would my lord just look? Please read this with me, and then maybe your lordship may be able to appreciate what
No, I am referring your own document which you have filed in this compile.
Yes, yes, my lord, in the interest of fair and complete disclosure, my lord, we filed everything.
This
But
is
please come to page. Please come to.
Revise the toll rate applicable with from so and so. Categories are same: car, jeep, light commercial vehicle, loaded empty bus, loaded empty truck, multi-axle vehicle. That's all.
Lord, can I just read the MOU? Their own MOU says that I will comply with the classification scheme. Lord, I said, Lord, the state has signed an MOU with NHAI and IHMCL. What does the MOU say? I will adhere to the classification scheme. And that's how I'm in the fast tag.
Where is the direction for you to collect the toll on the basis of this fast tag?
My lord, I have been collecting. That's why I said.
So where is the?
My lord, please see.
Where is the agreement? Is there any supplementary agreement? Is there any direction from NPRDC? Is there any direction from the state government to collect the tax toll as per?
When I read the clauses in the concessioner agreement.
In your agreement, fee notification is the same. It is revised only. That's all.
Lord,
nothing has been changed.
Lord, fee notification. Lord, I'll show my lords. It's see 5th March. I'll show that all. First, Lord, can I just complete this or your lordship? Just one thing. My lord's putting a question and we.
Yes, we are putting a question. Directly is coming to that.
Yes.
This is the letter written by NPRDC dated. Aap hi come to page 56.
My lord just come to page 35. This is the MOU which respondent number 2 is executed with IHMCL. Correct? For the fast tax scheme. Please come to adopt the fast tax scheme. Please see page 30. My lord, the MOU starts at page 32.
32.
25th February 2020. My lord has that.
32. Yes.
And I would like to go back to the scheme, my lord. It can't be appreciated without having a look at the scheme.
Yes.
But please see page 32, 25th February 2020. Correct?
Yes.
And the parties are, as I said, my lord, IHMCL and respondent number 2. Please go immediately. And this applies to state highways, recital C, bullet point 1. To national highways as well as state highways. My lord, can I just read, if my lords don't mind?
Yes.
Recital C. IHMCL has released a scheme guidelines for inclusion of state city toll plazas under NECTC program, V-Day policy circular number so and so. Implementation of unified and interoperable electronic toll collection system for national highways as well as state highways, my Lord Hazard, in India to facilitate seamless movement by offering ETC services across all toll roads in India. This is the scheme. Now, D, MPRDC, an authority set up by the government of Madhya Pradesh, is engaged in several road building, other so on. So these projects are implemented largely under public-private partnership model like BOT, toll plus annuity, total toll plazas, 75 are the total, are operational on roads managed by MPRDs. And MPRDs wishes to implement national electronic toll collection system on all toll plazas of MPRDC, which includes the subject toll plaza. Now, F, my lord, MPRDC, in order to promote and implement the electronic toll collection on its expressways in state of Madhya Pradesh, is desirous to avail the ETC services being offered under the NETC program. Now, this is the proposal which MPG, my lord, has submitted a proposal to IHMCL expressing interest to include its toll plaza under NECT, covering in detail the total projects, etc., financial estimates, execute a separate detailed agreement. We don't have it, we must be having it.
That's why I was referring to. There is no separate agreement.
No, this separate agreement is between the state and IHMCL, my lord.
But, sir, where is the direction to?
My lord, please come to page 30. Please come to page 38. Well, my lord, can I read 2 and then 38? Because your lordships are asking me a question, I have to fast track it. But please see 2.2 and then I'll go to page 30.
Yes, 2 points.
Please come to page 2.2. Pursuant to this MOU, page 35. MOU, a contract agreement shall be entered into between the parties that will identify specific items and conditions for inclusion of toll plaza of MPRDC under the NETC program. The arrangement of so and so shall be continued with the validity of this period of ETC system deployed at toll plaza should comply with standard requirements and specifications. My lord, has that not? As issued by IHMCL and NHI, ensure upgradation, etc. And my lord, then C, determine acquiring.
Earlier in our High Court, there was a system of payment of court fees by affixing a stamp and everything. Now we have introduced payment through UPI to online. But that did not change the rate of court fees. We were earlier on a physical file, now we are on a, it's all convenience for you can't change the rate.
What your lordships are right.
250 is the court fees for filing of petition by way of physical or by way of e-filing.
No, not I.
So FASTag is a collection through electronic mode. But how it can change the rate?
I'll tell my lords how. Please see page 38.
Yes.
Lord, this is addressed to us to implement any TC scheme. Implementation subject is implementation of any TC and finalization of rate of acquiring services for toll plaza under jurisdiction of MPRDs. Your agreement, that's the concession agreement of 30th June 2000. As per the directions of the Ministry of Road Transport, that is MOT, MPRDC has decided to include state highway toll plaza under NETC program. Accordingly, bids were invited from certified acquiring banks for discovery of rate for acquiring services. As per the bids received, it was found that 0.24% collection through FASTag is the lowest rate for acquiring services. Accordingly, MPRDC has finalized 0.42% as the admissible acquiring fee to be reimbursed to the acquiring bank by the toll collection agencies for operating NETC program. Concessioners, toll collection agencies.
Or they have reduced the rate.
No. This is the rate for my lord.
They are giving you concession for.
No, my lord. This is not giving. Lord, please see. Your lordships asked me, are you forced to do it? I am saying yes, I am. This is the document. He says, please implement any TC.
What about rate?
My lord, the rate.
It is about the rate.
The rate.
But you can't enhance that rate.
I am not. What is happening is they are changing the classification. That's how the rate gets impacted. My lord, I have no leeway in deciding what the rate is. I said that at the outset. The classification also, my lord, there is no leeway with me. You told me, please switch to NETC. This is the classification. And therefore, for this classification, whatever is the rate has to be paid.
If we are promoting this e-filing, we can't.
It's not as like. India says we'll have it national. No difficulty. The government of India says this scheme can operate on the classification that I have given because this is an electronic mode. There is no human intervention. Now please come to, would your lordship just please come to this. Please come to page 30. Now, yeah, just one second. Your lordship should ultimately, my lord.
They are not changing and come to that revision of their toll. They have not changed the category.
They have. I'll show my lord. Please see page 28.
28 में आप इसमें इनके लेटर्स में ये एमपी आर्गुमेंट के लेटर्स
I will come.
अभी भी मल्टी एक्सेल बसेस को सेपरेट कैटेगरी में रखा है.
My lord, I'll come to that. Would my lord just oblige me by looking at page 28 first?
Yes.
If your lordships don't mind.
Yes, 28.
My lord, in fact, at page 24.
You are reading this document which is a part of this fast track scheme. We are referring the document which the MPRDC issued to you, revising the rate, despite this scheme. So why you are not following that?
But because you cannot operate in fast track scheme if you are classified.
It is their headache.
It's not their headache.
No, it is that they will deal with the government. You are only a collecting agent. You can't decide the rate.
No. My lord, please see this. So therefore, they can.
Union of India has not authorized you to do that.
Lord, please.
You are through MPRDC.
Lord, please appreciate this.
Yes, sir.
You get 1% monitoring fee.
In which they have given a relaxation of 0.4.
No, this relaxation is not given to me. They keep back 1%, 2%, 3%. Correct? You issue me, you tell me to move to this scheme. I move to this scheme. I charge according to, your lordships have not seen the classification. Please see the classification first. My lord, it cannot be equated with.
So then why they are,
my lord, I have some experience.
Why they are kept on revising the rate under that same schedule?
So that, my lord,
under the same fee notification?
Lord, please see, two things go together. Rate without a classification has no meaning. Your lordship will appreciate that. I will say 3 rupees for what? Per kilometer for what? For a bus, for a truck, for a multi-axle vehicle. You'll have to define, correct? So rate without classification has no meaning. Classification has to go with the rate. Now, till the time there was no electronic collection, the classification was different. When you change to this key, you said go by this classification. Now, I come back to the question and I ask myself, which I started by.
Where is that line?
Am I?
This classification.
May not answer.
In the letter. You go to this rate.
May not be. May not the system. May not the system. My girlfriend, we've all gone through this. At a particular age, you think your senior is not communicating enough to the judge. But I'm trying my level best. As I said, rate standalone has no meaning. You know, it's like saying your lordships have done so much of tax. I'll say tax at the rate of 30%. Who's to be taxed at the rate of 30%? Individual, HUS, company. You have to say who the SSE is. Similarly, in toll, my lord, you'll have to say rate is X, classification is so and so, marry the two, and then come to the toll collection. When they shifted to fast track, my lord, your lordships are looking at an impugned order where they are saying you are at fault. That is me, the writ petitioner. Now, if you told me go by this classification, I have no problems. For future, you say whatever you have to say. But for the past, you can't hold me guilty. That's my point. And then say you are in breach and pay damages. Lord, I wonder what happened. For 21 to 24.
What we are arguing.
Correct. And my learned friend wakes up. First, he goes to the issuer bank, which is his own bank. He applies. I'll show from his own counter affidavit, paragraph 5, H, where he says, I applied as per the classification given at page 25. I got my fast track. Then he went to him and said, no, sorry, I am a bus. They said, no, nothing doing. As per this classification, you are a bus with 3 axles. Your weight falls between 16.2 and 25. Therefore, your classification is right. And we are not going to change that. The government, realizing that they had made a mistake, Lord, after the decision of impugned decision of 21st May 2025, changes the classification. I show that, my lord. And as I said, my lord, the government has to come clean and tell my lords, what was it doing between the very same period where it was collecting the tax? Was it doing it on the basis of the classification that is stipulated by NHAI and IHMCL? If it was, then it can't be sauce for the goose and not sauce for the gander. Which is why, my lord, this is important. Please see page 26. Lord, it can't be. You have to marry the classification with the rate. Please see page 25 with me.
Yes.
The state can tomorrow decide, listen, I don't want to collect more. Who am I to say? But the state can't say you made a mistake and therefore we are going to disgorge the amount from you and you pay the damages. My lord, you can't find fault with me. That's my point here. From today you say, like, my lord, there is an interim order. Your lordships asked me for urgency, but I didn't want to seem that we are not wanting to argue the matter. There is an interim order, and as per the interim order, the notification that they have taken out, charge them as a bus, is being done. So the difficulty is twofold here for the petitioner. And why is the petitioner before? One, you are holding me guilty for something that I have not done. I did what the agreement required. That means I will issue a fee notification. There will be a classification, collect accordingly. I collected. It went on from 21 to 24. 24, this man gets up and says, I'm giving you a representation. This classification is wrong, even though I got a fast tag based on the classification that NHAI has stipulated, which is axle and weight. It suddenly wakes up, it doesn't do anything. He comes to the court, usual, my lord, your lordship say, dispose of the writ petition, they dispose of the writ petition. Dispose of the representation is disposed of, and this impugned order is passed on 21st May 25. On 30th May, my lord, they realize that after 2009, post 2006, the lordship saw in 2006 is multi-axle truck. They changed it to vehicle. They realized if it is vehicle, then again under the scheme, the fast tag scheme, he will come under the vehicle. They changed it to truck again. जैसे कहते हैं अगर आपकी गाड़ी में तिनका ना हो तो ये करने की जरूरत ही नहीं. Which is what they did. Now the question is, Lord, am I at fault between 21 and 24? When you issue notifications, and this is, and please see this, Lord, my arguments will be complete after that. Only, if your lordship would see page 25.
25.
24 and 25. It starts at page 22, Lord, it says fast tag issuance, vehicle classification document. And please see the background at page 24. And this is important to appreciate what the problem is here.
Yes.
Fast tag program was stated by IHMCL and ICICI Bank, which was the issuer bank, the vehicle owners bank.
Yes.
Sorry,
yes.
My lord, see background. It says it's important. Fast tag program was started by.
You got your point.
My lord, your lordships have. My lord, even I.
Following this.
I must say candidly, my lord, my learned friend came to me. I said the same thing with my lords. And when I did go deep into the matter, I did understand from where the petitioners are coming. The petitioners are saying the state is entitled to say, because as per the concessionaire agreement, that I will fix the rate, no difficulty. State has to tell us how to classify and which rate to, because I said both have to go together. They said from 21 to 24, I did the same thing. This fellow kept quiet, or at least didn't take R2 to court and said, listen, what you're doing is not right, whatever it is. And now the state says the shoe is on my foot. When you issued me a notification, you told me collect it in accordance with the NHA.
That point.
Correct?
And
Now, Milord, Milord, I'm sorry, I'm taking a little more time, but please read page 24. Because it can't.
No, you fix your own time, 45 minutes, that is over. At the very beginning, you said 45 minutes.
I said 45 minutes to an hour.
Please conclude, we will find out.
I'm sorry, Lord, sometimes it does happen because questions fall. There is an iteration of thought, and I know, Lord, your Lordship will be open till the last. And
Yes.
There are some impressions cast in.
Please avoid repetition. Please avoid.
Lord, I try my best not to avoid, have repetition. But this document I have not read. But please go to straight away 26th.
Yes, 26 is before us. Yes.
Has my Lord seen that?
This is a table.
Yes. It says mapper vehicle classes. NECT mapper is repository of any TC tag ID is maintained by so and so, switching to so on. So now mapper vehicle class 8, bus 3 axles. There is a bus of 2 axles also.
Yes.
They are different classes. There is a mini bus also, there are trucks also. Now see tag vehicle classes, page 27. Correct, Manoj?
Yes, there is a classification of vehicle. Where is the rate?
As I said, you cannot have toll without classification of vehicles.
This is the rate for truck axle 2, truck axle 3.
Yes.
The rate.
MPRDC has done, I show page 38.
No, they have put all these things in a one category.
Just see 6 first and then I'll come back to
yes, 6 and 54.
27, 6, it says 3 axle commercial vehicle, correct? And no, my lord, I wanted to read this because your lordships are saying, no, hurry up and don't finish it. I will sort of, PC page 29.
29.
Yes. We see the pic. They have also, because there was some confusion, and that is what is given at page 28. I have not read it because your lordship saying please complete. Please see page 28.
Yes.
2 axle vehicles, your lordship would see in the sample image has 2 axles. They mark those axles in the picture. Does my lord have that?
Yes.
That is for trucks as well as buses. There are buses with 2 axles. Then come to page 30, which says bus 3 axles, mapper 8. Does my lord have page 30? And please see the picture of the bus.
Yes.
It's that long luxury bus which has 8 sets of wheels. And the weight is also given, not in. Okay. Now come to page 38. His own RC and his own stand in the counter affidavit. 38.
Yes.
Not 37. I want my lords to see 37 also.
Yes.
Because the state said in the middle, my lord, your lordship will find Bhopal, Devas, because they have given the state highways where this scheme will operate. It's 1, 2, 3, 4, 5, page 37. At serial number,
Big road.
it says,
It's a broad road, Bhopal Deva.
yes, it gives the company petitioner's name. It says it's to run for 25 years, etc., etc. So we were clearly covered. Now come to page 38, which I read and I'm respectfully emphasizing. They said implement the any TC scheme. It's given in the subject itself, implementation of any TC scheme. And please see page 39 now. There is a clear direction to all BOT concessioners. Page 39.
Yes.
This is 24 May 2023. Implementation of guidelines of August 2022 across all toll plazas, MPRDC and concession contract agreement and schedule. Scheme guidelines for inclusion of state safety, etc., etc. This is in reference to FASTag TTC facility. ETC facility installed across plazas in the light of concession contract agreement. In this regard, IHMC then had issued circular in August 2022, wherein PMF charges of 1.3, etc., shall be deducted, etc. Please be informed that aforesaid IHMCL policy shall be applicable in totality from so and so time 00 hours from 25th May 2023 across all toll plazas of MPRDC. Hence, you are instructed to ensure implementation and smooth functioning of toll plaza. Now, please see his own stand in the counter affidavit. Lord, R3.
Yes.
And RC.
Yes,
Lord, I'm so sorry. If my lords would just guide me and look at his RC.
RC is before us.
Page
Reply
60.
by respondent number 3.
64. My lord, your lordship would see that he has got 3 axles.
Yes.
Convenience fiber. Page 64. Page 61. 63, my lord.
Yes.
Of the convenience compilation. My lord has it.
Yes.
Page 64. And it is, and my lord, bottom left hand side, number of axles 3. My lord has that.
Yes, 3.
And the weight.
Followed.
Correct. And this is chartered speed. This is respondent number 3's RC. Now please go to his affidavit, counter affidavit.
Yes.
Page 75. Yes, my lord. We have extracted the relevant part of the counter affidavit, which is at page 75. Lord, starts at 75. The relevant part at 78. Right?
Yes.
I am the contents of paragraphs also I am at page 78 are denied as the same does not depict the true facts because the issuance of fast tag, which was done in reference to NECD fast tag issuance scheme, as per the guidelines, respondent number 3 comes under mapper class 8 and tag class of 6 is issued as per guidelines. This is his admission. Further, as per the notification of so and so, the description of respondent number 3 vehicle comes under serial number 3, not under serial number 5, multi-axle truck. This was changed to vehicle in 2009, and after the impugned decision on 30th May 25, it was changed back to truck by the state because they knew there was a problem. And that what I was saying was right, that they couldn't have found fault with me for the period between 21 and 2024. So, my lord, as far as as far as they going and asking the issuer bank, which was ICICI, their bank, they went in 2022, and I don't think that was, they didn't get relief there. They could have taken up the matter then. That is respondent number 3. They did not. So therefore, my lord, my answer to the various queries that my lords have put is briefly this. So, my lord, my submission is this to sum up. As far as the petitioner is concerned, I am a concessionaire. I do not have leeway vis-a-vis fixing of rate or classification. Rate and classification, as my lords put to me, is the domain of the respondent number 2. And I recover my cost or whatever profit is embedded over a period of 25 years by collecting toll in the manner stipulated. Toll was collected manually between 2006 and 2020, when the fast tax scheme came. When the fast tax scheme came, they changed the classification. When they changed the classification, it was at the relevant time multi-axle vehicle. Bus, there was no reference to axle. This scheme said you have to charge for buses. There are 2 kinds of buses, those which have 2 axles and those which have 3 axles, and that weight range that I have given. Therefore, charge accordingly. I collected. Respondent number 2 was aware of the fact that I was collecting. Respondent number 2, the instrumentality of the state was getting its monitoring fee at the stipulated rate. Now see the impugned order where they say in paragraph 8, but you have collected excess. If you issued the notification and you said collect, and I was collecting, not in a hidden manner, my lord, known to everyone, including him, which is why he went to ICICI Bank, the issuer bank. They said, no, classification is all right, we will not change. Then to find fault with me and levy damages. Damages means there is breach, you've suffered an injury. Those principles of law don't get varied. How can you in an impugned order now say that I am at fault? That's my respectful submission.
Yes, Mr.
And my lord, this please 83, that last one document, 84, what I was just referring to,
Yes.
is the change in the second respondent stand. This is 30th May 25. After your lordships had passed a stay order on 29th May 2025. The impugned order is 21st May 2025. The stay was 29th May 2025. And this order was passed on 30th May 2025. Where, if your lordship would see the last part, I do not need to read more. The last part where it says, or the last three lines, which is also part of it is categorically mentioned at serial number 5, the category of vehicle as stated in the letter issued on so under reference to be read as multi-axle truck instead of multi-axle vehicle. From 2009, it was vehicle. They made it truck because they knew that if it is a question of, my lord, saying axles, it could be a vehicle, correct? Which was the situation pertaining in 2009, and after 2018 we aligned with that. So the rate that we charged was for multi-axle vehicle as per your notification. Realizing that they were in the wrong, after the impugned order, they go back to truck because then no one can say bus and truck are the same. I wonder will not make it. So my respectful submission is the state cannot take two different stands. It has to be even-handed. It's the instrumentality of the state. It cannot say, I was in breach when, and they have not said that before your lordships, where they were collecting, were they following this scheme? Two, that I was in breach when you issued the notification, I did it, Lord, under your umbrella. And then to say damages. As your lordship said, I can't put it higher than this.
Yes, yes.
So, my lord, first and foremost, my lord, we have raised one objection, my lord, with regard to maintainability of this application. There is a detailed dispute resolution mechanism which is provided in clause chapter 33. My lord, may kindly permit me to take your lordships to that one.
Arbitration clause.
And your yes, a detailed, my lord, dispute resolution mechanism. So all these things, my lord, these aspects cannot be adjudicated here in the writ petition. Now, your lordship may kindly see, in the light of the concession agreement, which was executed as back as on 30th of June 2007, sir.
Yes.
So there was no confusion in the minds of the petitioner, sir, from 2007 up to April 2022. Well, they were charging as per the fee notification. There was no confusion. Truck kya hai, bus kya hai, फिर multi-axle kya hai. No confusion, nothing. Since the year 2000, the FASTag, it came into existence, sir. Even after coming into force of FASTag, there was no confusion in the minds of the petitioner. It has happened only, my lord, after April 2022. They have, and my lord, our clear stand in the return is that this mischief is played by the petitioner. My lord, whatever command, whatever input command is given to the computer by their IT engineer or by their expert, my lord, the data operator, well, accordingly, my lord, the deduction of toll will be done. So under wrong category, my lord, they have started deducting toll after April 2022. And my lord, present is the second round of litigation, sir. Initially, in the first round of litigation, this honorable court, the Indore bench of the honorable court, what they did, sir, initially, they treated the territorial jurisdiction of this issue before the honorable Indore bench. So first writ petition they filed there because matter relates with the Devas Road. So, petition. Respondent above. Yeah, respondent.
We are clear. Just clear about it.
ठीक. So, respondent. So, my lord, that, yes, ma'am. Now, my lord, in compliance to the direction which was issued by the Honorable Court, we have considered and decided the representation.
Because the road starts from Bhopal, that's why this.
Ji.
That's why we did not. Had it been an Indore Deva, then we could have sent this matter.
So no, in fact, I have no objection, my lord, in that regard. It is before the Honorable Court. So now, sir, we have taken very clear stand. My lord, may kindly permit me to refer paragraph 6 onwards of my return. Your lordship may kindly take, I have a reference to this, my lord. This reply we have filed on 2nd of June 2025. My lord may kindly see para 6 onward. Now, the fee notification initially it was issued on 30th of December 2006.
Yes.
My lord may kindly see serial number 3, empty and loaded bus. Then serial number 5, multi-axle truck. There was no confusion. My lord may kindly see. Now, my lord, Hindi की अधिसूचना भी देख लेंगे sir. That is also important. Page 147 of the covering memo. इसको भी देख लेंगे सर. 30/12/2006 का हिंदी में नोटिफिकेशन क्या था? This is very important, sir. Covering memo का ये page 147 है सर. हमारे covering memo का ये हमने
Covering memo. Page 147.
serial number 27 पे है. Page 147.
Digital page बताइए उसको. Yes, मिल गया अधिसूचना.
ये हिंदी का है अधिसूचना.
38/26.
जी 30/12/2006 अधिसूचना. इसमें भी देखेंगे साहब सीरियल नंबर 3 पे लिखा हुआ है खाली तथा भरी हुई बस. और 5 में देख लेंगे सर मल्टी एक्सल ट्रक ट्रेलर. इंग्लिश में लिखा है केवल मल्टी एक्सल व्हीकल, जो आप देखेंगे नोटिफिकेशन में. हिंदी के नोटिफिकेशन में लिखा है मल्टी एक्सल ट्रक ट्रेलर. Now, my lord, concession agreement was executed in the year 2007. There was no confusion in the minds of the petitioner, my lord. और आप देख लेंगे सर ये आता है हमारा पेज पैरा 7 के थोड़ा सा ऊपर देखेंगे सर हमारे रिटर्न का फी नोटिफिकेशन हमने कोट किया है पैरा 7 के ऊपर. इसमें लिखा है सीरियल नंबर 8 पे लोडेड एम्प्टी बस. टोल का रेट है सर सर सीरियल नंबर 8 में देखेंगे सर लोडेड एम्प्टी बस है सर 410 रुपए टोल. सर मल्टी एक्सल व्हीकल का है सर 983 रुपए. We have specifically stated in paragraph 7 of our return, sir, that it is their computer operator who deliberately made this entry, wrong entry in the computer, and got excess collection of toll tax. This is our stand. This is our stand in the return. And therefore, sir, what my respectful submission is, why I have referred the dispute resolution mechanism. All these things, sir, in a better way, they can be adjudicated upon in the dispute resolution forum which is prescribed in the agreement, sir. So therefore, sir, my respectful submission is that this petition,
you could invoke that forum. Any party can invoke that forum.
Sir, ये 21/5 annexure P14, sir, they have filed it. 21st of 5/2025, we have already appointed expert bodies to assess the excess collection. So approximately 50 to 60,000 rupees per day, they have collected excess toll. But then we have appointed, sir, expert body, and we'll get it, assess, what is the actual amount of the excess toll collection per day. But approximately, sir, we have mentioned in our return that 50 to 60,000 per day they have made excess toll collection. No, my lord, my respectful submission is that, sir, yes, my lord, one important thing, sir. Annexure R4 I have filed, my lord. Sir, colored, we have filed a screenshot so as to demonstrate how, my lord, this can be manipulated by the person giving wrong command to the computers. Annexure R4 may kindly be seen. कलर्ड में मैंने फाइल किया है सर, कलर्ड एनेक्शर है,
कैमरा स्कैनर।
हाँ, सर उसमें डाल दिया जाए गलत एंट्री, वो जैसी आप एंट्री डालेंगे वो कलेक्ट करने लगे,
ऑटो को बस पड़ेगा।
हाँ हाँ सर, ये कलर्ड में मैंने डाला, आप उसमें देखेंगे, ये देखिए सब पहले ही आप पेज 78 में देखेंगे सर, 18 में मल्टी एक्सल व्हीकल डाला था, बिल्कुल ऊपर देखेंगे सर 175 रुपया आ रहा है इसमें, ये बस डाला है सर। नेक्स्ट पेज में और लास्ट सर पेज 20 पे देखेंगे, हमने जब बस डाल के देखा तो ऊपर आप देखेंगे टोल का रेट आ गया 75 रुपीज। तो जिस तरह की कैटेगरी डाली जाएगी वैसा टोल कलेक्शन होगा। 2007 से अप्रैल 22 तक कोई कंफ्यूजन नहीं था साहब, अचानक ये फिर एक्सेस टोल कलेक्शन हुआ 50 से 60 हजार रुपए पर डे। So therefore, sir, my most humble submission is, sir, that
happening with petitioner only. We have a number of concessional agreement, number of roads that is expected by the LTIDC.
But as of now,
petitioner is charging excess or not? No other. But for other road, no one has made any complaint.
Petitioner, as of now, we have not noticed. But for petitioner, we have not noticed this. कि एक्सेस टोल कलेक्शन ऐसा हमारा सर हमने सब देखा है, लेकिन अभी तक यही एक केस पकड़ में आया है जिसको हमने ये, और सर इसको हमने पूरा एनेक्शर आर को फाइल करके ये भी डेमोन्स्ट्रेट किया है कि किस तरह से रॉन्ग एंट्री डाल करके और ये सब मैनिपुलेशन हो सकता है। My respectful submission is, Bharat, that this writ petition may continue.
After 3 months.
He's also party.
But still, Lord, will give me 5 minutes. Rejoin.
Lord, this case.
You are here because of whom?
Very happy to be.
And I am also very fortunate to meet him and have a chat with him. Anyway, Lord, in my respectful submission, this case is not the case of facts at all. Neat and pure question of law is involved. So bowing down to the submissions of the learned advocate general, in disagreement that this may not be sent to arbitration. Since your lordships have invested more than 2 hours, almost, let it be decided on merits. Yes.
No confusion, decided on merits.
Yes, so learned advocate general requested your lordships to refer it to. Now, my lord, how this matter stands? What, my lord, the bank took the view, what bank said to me are wholly irrelevant considerations. It is only your lordship's interpretation, that not the bank's interpretation, or not by some concessions, though they are not, are said to have been even concession against law, unless it is a concession that though you have wrongly collected, I forgo. Then I can't come and complain before your lordships that I have though said that yes, you have wrongly collected, but I don't want it back. Then I can't waste your lordship's time. Now the question is 2006 notification. It's a GR. Government resolution, my lord, power flows under to frame or to come out with the resolution under Article 162, where the field is not occupied by statute, or where it doesn't come in conflict with the statute. It is an absolute power of the government to come out with the GR, and those powers are not statutory in character. The powers are Lord, flows under the Constitution under Article 162. Now that GR 2006 is in the name of His Excellency. And it's only then said to be a GR. Unless it is not, Lord, in the name of Governor, Lord, it can't be a GR. It is a foolproof policy. Now, consciously government has classified bus and truck or vehicle as a separate units.
In a broad sense.
In a broad sense. Now, my friend relied on 2009. Please come to page 40 of his convenient compilation. And he sought to argue at page 41 that multi-axle truck has gone and vehicle has come. It ignores one fact that clause 3 also remains. So whatever you have to read under multi-axle vehicle cannot include loaded or empty bus because that's a class by itself. Had it been a case in 2009 that 3 and 5 both would have gone and substituted by multi-axle vehicle, possibly had some grounds to argue. But bus is kept as it is. It is not deleted. Had 3 been deleted and 5 been substituted from the word truck to vehicle, possibly he had some chance to argue.
Multi-axle vehicle, irrespective whether it is a truck or bus, that will be charged by rupees 150.
That is what, Lord, his argument is. My argument is, had these 3 been deleted, that is loaded or empty bus.
3 and 4 category, bus and truck.
Yes. They are separate class. They can't be included in multi-axle vehicle. And that's the policy of the state, to which he has not challenged. From 2009 till 22, buses were, my lord, charged or toll was imposed as bus only under category 3.
10-seater bus, similar to the multi-axle sleeper coach.
Even then, my lord, he could have come and told your lordships that this is not a classification. Your lordships are right, but bus will have to be read as a bus.
Constructed a road, and they have to maintain the road. For
So therefore, there is a.
Please permit us to complete the.
My apologies.
Maintain road for 25 years. They are conscious about the load on the road.
I bow down. But that argument is self.
10-seater with bus of 72-seater, they're carrying the same load. Or same with the truck.
No, ours are seater bus. Ours are seater bus. Ours are not, my lord, sleeper coaches.
Yeah, deciding on a broader, not.
I bow down. But then it is self-destructive. Once he concedes that they can issue a direction from tomorrow, that means they accept it. Kindly appreciate it. My friend's clear concession that, all right, from tomorrow you can say, and we will bound, and we are bound by it since last 1 year. That is a self-destructive. Once you concede to the powers of the state.
Motor vehicle act. No, define it. Vehicle
And we're reading the order.
Yes, sir.
Reading the order. But there is nothing wrong in the order. And state has continuously taken a stand. And as Lord, rightly it fell from my Lord Justice Rusia, that state has not permitted them to go by central government notification. On the contrary, stand of the state is very important. That we will not go by central government charges. We will be governed only by 2006 government resolution.
In motor vehicle, there is a category heavy passenger motor.
There is.
किलोग्राम.
Yes.
Light motor नहीं, bus के लिए भी category.
Yes, yes.
Maxi cab, medium goods vehicle, medium passenger motor vehicle.
They are not buses. They are matadors.
Motor vehicle.
Yes.
Omnibus. Then.
They are different.
Semi trailer, stage carriage.
Yes, they are different.
Buses and trucks are there.
No.
Depending on their load capacity.
So load capacity is not described under MSCT. Their broader classification is there. It is not under road. But here, you know, state stand is very clear. Though we are accepting fast tech policy of the union, there is nothing today coming on record which permits them to charge as percent. They charge, they are very clear. And that is within the domain of the state government. Because these are state highways. Had it been a national highway, state possibly could not. But these are highways which state has to construct, which state has to maintain. Under delegated powers, it has been given to a contractor as a concessionary. But not that automatically that policy which my friend read of 2020, February 2020, would be applicable in terms of dates. As Lord, not because it was in my favor, but as rightly, my Lord, put by my lords, that method may change, rates will not change. Rates, you need the backing of law or backing of a GR. Unless there is a statute which steps in, then GR has to rescind into background. Then 2006 GR would not stand even for a minute if statute creeps in. But otherwise it is absolutely for the state to accept the policy in part, accept the policy in total. This is all.
5 minutes.
And only a minute. Only a minute. Yes. And everywhere, loaded and empty bus has been a class by itself. Has been a class separate.
Both carry the same weight.
No, bus and loaded and empty bus stand. In GR it is not classified. Here under 226 he can't ask your lordships to classify. Simply because.
Only XL, not the,
Yes. No, but XL also. Central government has said if the state has approved it, and now state is coming back, then my friend has 100%. If it is approved by the state, rates wise, XL. If state has not approved, state has approved only to go for fast tech policy of the union. And for that, state has to categorically either amend 2006 GR or supersede 2006 GR. But not otherwise. That is how it stands.
5 minutes. Learned AG's submission to my lords. This was a submission to create prejudice. That someone tinkers with the system, and that's what we have done. It's completely wrong. Firstly, there are two banks in. There is an acquirer bank, which is the ICICI bank. There is an issuer bank. It was also ICICI. One time it was Paytm or something. I had no role. Page 90 that my lords were shown by the learned. Please see the timestamp. It's 1st June 25 after the impugn order was passed on 21st May 25. And like a good citizen, I said, there is an order against me. I will change under protest. This is 1st June 25. Not that someone fingered. One, the learned AG, my lord, with respect, did not answer a crucial question. When this was happening, and that goes to my learned friend's client also, did you come to court and say this is wrong classification? You did. You actually applied under the classification as admitted in paragraph 5I of respondent number 3's counter affidavit. The learned AG does not answer, are you wanting to disgorge the monitoring fee that you have collected? And how do you find fault with me from 21 to 24?
22 to 25.
Okay, 22 to 25. I stand corrected. They don't want to say anything. But I am surprised that the state is taking this stand. Why? It is not only this entity, point number 3, there are several who are waiting on the sidelines. Is the state going to disgorge all that money? And as your lordships rightly pointed out, why is it collected more toll from vehicles which are heavy? Because there is wear and tear. The highways have to be maintained. There is some logic, rational in the legislation vis-a-vis weight. Now,
That came from the court, not from you. That
Lord,
argument came.
Lord, I can only say there is a lot of wisdom that automatically flows this side, my Lord. It perhaps, Lord, we can only assess my lords now. Now, I didn't want to go because it is so logical.
No, I wanted to say the weight has a correlation with the capacity of the road.
Correct.
There is road has some bearing capacity.
Correct. There is some logic.
There is a prohibition of flying of buses and truck on a Pradhan Mantri road. That is inside the village area because we can't carry that road.
Correct. Now, therefore, my learned friend doesn't say that he is, those visuals, if you see those buses, long buses, with 8 wheels, he doesn't dispute that this is a 3-axle bus, which is different from a 2-axle bus. Therefore, my lord, today to put the onus on me, what the impugned order has done.
But 3 or 2, I'm sorry, is not relevant, my lord.
So, my lord, may I respectfully submit? The point is, the state is putting the onus on me that you are in breach of conditions. I am saying, no, I wasn't. You are aware. In fact, my lord, I would persuade, if your lordships have not been persuaded, what is the state? The state is not willing to file an affidavit as to what is being done in other cases.
Concessional agreement is like a loan repayment by your EMI. You invested, suppose you invested 500 crores in construction of the road.
Yes.
So how you will get back your 500 crore
plus 20
service charge by your fixed amount of recovery of toll for 25 years or 20 years. You can't increase the EMI or for recovery of that fee. So you will recover more than the amount you have invested. So that's why NPRTC decides within how much period, if you charge this amount from this vehicle, you will get back your amount in 25 years.
Correct. Your
This is the system.
No.
So, but you can't change the EMI. You will change the EMI.
I am not, my lord, please see, what is the impugned order? Why am I here? Because if your lordships were to sustain the impugned order, what will happen is the next step is they will say that the High Court has sustained the impugned order, you were in breach, I will terminate your agreement and I will not get any other contracts.
Yes.
Those are the consequences. Whereas the state.
No, I'm sorry, consequences can't be that.
Sentence by sentence.
Let's close it.
Mr. Oza.
No more.
I am in rejoinder.
No more consent.
I didn't interrupt. Very well. Right. Leave it at that.
Only 1 minute.
Written something.
But only 1 minute if you're not. Only 1 minute. If you're not.
Only classification.
Not only 1 minute, not only 1 minute, not more than a minute.
Written something.
Just 1 minute.
And the state
Only 1 minute. So my friend cannot justify it on the ground that I went to the bank or I committed an error, assuming I committed an error. That will not entitle you to charge more. And secondly, my lord, apropos before lunch when it fell from my lords, it's better I clarify.
System, there is a facility you can record your argument and upload in the video.
No, I know, my lord. I will. Just 1 minute, my lord. Just 1 minute. My lord, from 21, this increase came in 22. From 21 till date, we have not increased a penny. The bus charges have remained the same. So it's not a case of undue enrichment.
One has to be very, very relevant to accept that this cost was not passed on to the customer.
No.
The state is
My lord, Mr. Advocate General can tell your lordships. We cannot increase it without the prior approval of the state. And state has not permitted us us means all operators. From 2021 till date, our representations are pending. That please permit us increase, please permit us increase. This could not have been visualized because this fell from the honorable court. That you must have passed on the buck, but we haven't. Every operator has to, but state of Madhya Pradesh and state of Bihar are the only states which have permitted private bus operators to ply. In rest of all other states, it's illegal. Only in these 2 states, it is legal to ply. Private operators are permitted. And all the rates are prescribed by the state government.
Deeply obliged, not for patient hearing.
Obliged.
Now we'll give written submissions in 2 days.
Will it be fine if we give it by Monday?
But would be
Within 2 days. In
5
short. Huh?
5 days.
2 days.
5 days.
Very well, give it in 2 days.
Matter of course, beyond 3 days.
We'll give it in 2 days by Friday.
You can upload it in reference.
We do it in 2 days. We do it in 2 days.
Mr. Sapre can do that.
Deeply obliged.
Obliged.
Any urgent matter, we cannot wait till next week.
Item number 35.
Bataiye.
This is the matter pertaining to my lords, the reservation in favor of the physically disabled persons. And by the misreading of section 34, my lords, all the candidates who are suffering from the blood disorders have been excluded. In the previous date, my lords, उसमें reply नहीं आया है, and now the date of submitting the last date for submitting the form is but only submission. They may file with their reply within a week, so that I mean
May I mention item number 48?
48.
The Lordship was pleased to grant from the list appears.
2016 है
इसमें सर 48.2
2018 के बाद आप लग रहा है
48.2 में कोर्ट स्लिप दिया सर पर
क्या है
अर्जेंसी नहीं मैं ये बोल रहा हूँ सर 48 and 48.1 they are not connected with the rest of the 2 cases in which the court slip was granted.
नहीं इसमें एप्लीकेशन आई है विड्रॉवल की
सर ये 48.2 में आई
हाँ तो उसको विड्रॉ कर देते
सर 48 and 48.1 are different.
अरे एक मिनट 2166 और 2019 डॉक्टर जीपी पांडे
जी
इसमें एप्लीकेशन है विड्रॉवल
जी
किसने लगा
Initially, I filed the WS. Subsequently, counsel has been changed.
But it is supported by an affidavit of petitioner. So ये
I'm not aware.
पांडे वाली इसको विड्रॉ डिसमिस से विड्रॉ कर सकते हार्ड ऑन आईए नंबर को इनको करते बाकी में तो नहीं है ना आईए
I'm not aware.
हाँ तो आपकी पिटीशन चलेगी जो इनको विड्रॉ करना करना
नहीं सर ये 48 and 48.1 are said to be linked with the rest of the 2 cases. They may be de-linked. 48 and 48.1 they are land acquisition matter.
एक तो विड्रॉ हो
जी
दूसरी डीलिंग करो आपकी तो सर्विस मैटर होगा
सब हमारा 48 और 48.1 है that is land acquisition matter.
My lord, may I make a mention for serial number 29, my lords? It's a PIL matter, my lords. The matter has been listed today on mention memo, my lords. The urgency is that on government land, a private person is continuously raising encroachment and has built his personal residential house over the property, my lords. No, my lords, during course, from the date of notice till today, my lords, the construction has been there. My lords.
My matter is.
If it may kindly be kept for tomorrow, I was just praying that, my lords.
47 is urgent, my lords. I have come before your lordships challenging a notice of demolition. Here it is a case, my lords. Annexure P1 is the notice. Now, my lords, admittedly, the
सुनना पड़ोगे
lords,
My lords, may I have a liberty to mention a matter? One matter was listed yesterday, item number 46, and your lordship. Lordship, there is an urgency in the matter, your lordship. A bank guarantee will get in cash.